My lord, may I have lordship's kind leave to mention my lord applications in connection with second appeal. My
Yes.
lord, one is restoration, two are my lord substitution, another is condemnation of deed.
3 applications.
Four applications.
My lord, may I be permitted to mention for listing the matter, my lord?
What is the matter?
Matter can application number 2710 of 2007, including essay.
Okay. Applications.
More than 17 years, my lord, pending. 2007,
No, I will take up the matter
Fine.
under the heading applications.
my lord.
Yes. Appeal. Second appeal. 2003. Okay.
Lordship, may I be,
Your Lordship, may I be permitted to mention?
Yes.
Lordship was pleased to pass the judgment on 24th February 2025. There is a minor typographical.
my lord,
May I have a lordship's?
Do we mention?
my lord, may I be permitted to mention for correction, my lord. There was some.
Do we mention?
My lord, may I have your lordship's kind leave to mention one matter, my lord, for upgradation second appeal hearing. My lord, I have mentioned, my lord, the same case I have, Mr. Jana has written that he has no objection for fixing on any date, my lord. He is not able to appear on that time of mentioning, so he has written that I admit any date may be fixed. Please inform me the date as will be.
You are the
I am for the
applicant.
appellant, my lord. 1986, my lord. My lord, kindly fix any date, my lord. My lord, I will be
This is
deeply
the
obliged.
second appeal for the year.
For the year 1986.
Second appeal for the year 1986.
The SAT was the second appeal tender was 1986 and essay number was given in 1993, pending in High Court from 1986.
I can arrange a date for April.
Any date, my lord, any date, any date on my lord's convenience.
Is it in the list?
It is in the list. It was on the list on 7th March 2025 as item number 41. Last Friday.
Let the matter be upgraded.
Your Lordship,
It is in hand. Every Friday it is coming on the list.
So you have to
Second
mention on Friday.
again on Friday.
Yes. Otherwise, I cannot pass any order.
Okay, my lord.
I have to pass an order. Otherwise, the matter cannot be upgraded.
My lord.
You understand?
My lord.
You come on Friday, I will upgrade the matter.
My lord, please.
May I have your lordship's kind leave?
Friday list.
Your Lordship, two
Yes.
second appeals are pending since 2006, and in the said two second appeal, substitution petitions are to be heard. One filed in 2014 and another filed in 2024. Let the matter be listed.
Applications.
Applications, Your Lordship,
So,
for substitution.
where is the slip?
I will submit the slip through Junior, Your Lordship. I will submit today.
No. You there must have one person to hand over the slip.
Yes. Within 5 minutes, I will.
Otherwise, this way cannot be taken up. You understand the issue?
Yes. I will submit the list in chat box if Your Lordship permit.
Have you served before?
Yes, Your Lordship. Only state is there. Only state.
How state is there?
Only state is there.
Who are the respondents? Only states.
State of Goa. Yes, Your Lordship. State of West
Second
Bengal.
appeal. Second appeal.
Second appeal. Second appeal, Your
State
Lordship.
is there.
Yes. Only
Have you
state.
served upon the state?
Yes, I have served. I have served the applications.
Okay,
Both
okay.
the appeals.
Okay, give me the slip.
May I have your lordship's
Submitted,
kind?
Your Lordship. Obliged.
Under the heading application. Yes.
The Logima matter.
Logima matter. Logima matter for what?
Because of the
I don't have the determination of logima matters.
Logima means the Logima court.
Yes.
Used to direct the lower court to send the LCR. After I have already deposited the cost. Thereafter, the learned Logima court has been pleased to direct this matter be placed before the learned court. Kindly see this order.
Logima court cannot direct any court to take up the matter like that.
Kindly see
You know the determination is there for the Logima court. I understand the second appeal matter.
Logima court has been pleased to give liberty if they not send the LCR. You pay liberty before the learned court.
So why you are mentioning like the Logima matter? This is not Logima matter. This is a matter in connection with the second appeal.
Sorry.
The Logima matter, this
No,
court
Logima
don't have
matter.
the determination.
Logima matter before the.
This is in respect of the second appeal
Yes.
under the heading of applications.
May I have your lordship's kind leave to mention a matter, your lordship. This item is running as item number 97 in your lordship's
90?
daily 97 in the
Page
daily
list.
list. Yes, your lordship. Lordship, I am praying if this matter could be taken up tomorrow under the heading of mentioned matters. This is one of those notification matters, your lordship.
97, it is under the heading of hearing group 8 matters.
Yes, your lordship.
This is hearing matter. So how can it be upgraded? It is already within the 10 matter.
Lordship, this is a new motion.
No, not
As
new
to-
motion. This is hearing matter.
Lordship, I might be mistaken for the item number, your lordship, but this is under the hearing of new motion. So heading of new motion. If this could be taken up tomorrow under the heading of mentioned
this
matters.
is hearing matter. You see the list. 97 is the hearing matter. What matter you are mentioning? 79 or 97?
No, please.
Get prepared. Okay.
My lord, may I be permitted to mention a matter, my lord? My lord, it's for inclusion in the list. It's a first miscellaneous appeal, my lord, for the year 2017, and I'm mentioning upon notice, my lord.
Your Lordship, may I permit to
Yes, sir.
mention one motion matter? This is the matter relating to vacancy notification, earlier vacancy under Control Order 2013. The date has been given on tomorrow, 18th of March 2025. If your Lordship kindly take it up as under heading mentioned matter, your Lordship, it will not take more than 2 minutes because your Lordship has passed several orders regarding this
Mention matters.
under heading mentioned matter. Your
Now, whether
Lordship.
it was listed,
No, it will come tomorrow.
let it be list first, thereafter.
Lordship,
As your
lordship,
Yes.
I'm mentioning the matter application. This matter is
In connection with
affirmed appeal number 660 of 2028.
second appeal or first miscellaneous appeal? First miscellaneous appeal for the year 2000? 2008.
My lord,
lordship,
may I allow to mention one application in connection with the second appeal, my lord?
Lordship, may I mention the application as well second appeal?
lordship, this was item number 79, your lordship. I
Then-
apologize.
You are saying the 97. 79.
Yes, your lordship.
This matter will taken up today. Just wait. Otherwise, I will fix the matter tomorrow. Call the list.
Second appeal ready for hearing.
For the year
2006 Lordship.
2006.
Upon notice I mentioned Lordship.
My lord, may I be permitted to be mentioned, my lord? I am praying for inclusion for an application connected to second appeal, my lord.
Call the list.
Yes, my lord. My lord, I am for the appellant.
I am for the
Plaintiff.
respondent, my lord.
My lord, suit for
Yes.
my lord, suit for declaration of title and permanent injunction. My lord, learned trial court passed the judgment and decree in favor of the plaintiff appellant. After that, first appellate court reversed the judgment and judgment. Trial court passed the judgment in the year of 2010, 25th October 2010, and it reversed the judgment first appellate court 26th February 2010.
Where is the paper book?
My paper book, I have served.
Give me the paper book.
My LCR comes.
Yes.
My lord,
What is the matter?
in the year of 2015, my lord, 14th September 2015, appeal admitted. My lord, 3 substantial question of law framed. My lord, kindly look at the paper book page, last 2 pages, that 3 substantial question of law framed, that whether the learned first appellate court was justified in dismissing the suit. Suit is barred under section 34 specific relief act without granting leave to the plaintiff to amend her pleading for incorporating therein for or recovery of possession. That when the learned first appellate court upset finding learned trial court judgment that possession regarding possession in the plaintiff is in possession of the suit property. This is the first substantial question of law frame. But under section 10, subsection 3, and number 2, they formulated the 3 substantial question. Number 2, that whether the learned first appellate court was justified in reversing the judgment and decree without settled principle of law that possession follows title. And number 3, that whether the learned first appellate court was justified in holding that suit is barred under Section 34 Specific Relief Act, though the defendant abandoned the said relief in the course of the trial. But three substantial question of law frame. What is the nutshell of the case? Mala nutshell of the case that the defendant's grandfather, defendant's grandfather, maternal grandfather, Kalipodo Maji, original owner of the suit property. Kalipodo Maji registered one deed of settlement in the year of 1966 in favor of the respondent defendant. After that, the defendant in the year of 1987 executed one deed of settlement, executed one sale deed to the plaintiff. And after that, the plaintiff is in possession of the suit property and enjoying that. And in the written statement, the defendant plea that due to some need of money only for 4,000 rupees, some interest 2,000 rupees, that the defendant respondent lent from the plaintiff to a plaintiff, and due to Saddo Sankranti of Kalipodo Maji and also the mother of the illness of the defendants. That is why he lent the money from the plaintiff. That is the main plea. And that on another plea that deed is not a sale deed, that deed is a mortgage deed, this is a loan transaction. This is in the written statement, that is the nutshell of the case. The first trial court passed the judgment and decree in favor of the plaintiff. Then reverse the judgment. Kindly look at the page 35 paper. Reverse the judgment. I shall come. Paper book, page 35. Page 35 paper book. Reverse the judgment, page 35. At first, I shall come. He win the case, then I shall come my case. 35. Learned advocate for the appellant has also argued that the original suit is barred under Section 34 of Specific Relief Act. The respondent is out of possession. She did not pay for recovery of possession. On the other hand, the plaintiff defendant examined evidence of 7 witnesses and they filed Exhibit A to H in support of oral evidence. All the 7 witnesses have told that the defendant is in possession of the suit property. My lord, I am surprised and I am very afraid when I have searched the cross-examination. My lord, I have filed early occasion the total serially which is kept in the record. Kindly look at the cross-examination. That I have filed. Serially, LCR comes, but that document I have filed.
Give me the document.
Cross-examination. It is serially, minor convenience. দেখুন এইটা একটা ফাইল করা আছে আলোকেশন আই সিরিয়ালি আছে তাহলে বলছি অনেক টাইম লাগে
কোথায় ডকুমেন্ট দিয়ে ওখানে ছিল দেখুন
এটা কোড ছেড়ে দেবো আচ্ছা দিয়ে দিন না ফেলে দিন এটাই দিন এটাই দিন এটা দিন সিরিয়ালি আছে কত
give me the LCR.
The copy of the same has not been served upon.
না this is a cross agreement serially in the LCR. That is the
এটা তো আপনি বানিয়েছেন
না এটা একই সেম না সিরিয়ালি আছে।
ক্রস এক্সামিনেশন তো সব দেখছি বাংলায় আছে।
হ্যাঁ, ক্রস এক্সামিনেশনটা এটা প্রত্যেক যেটা নিয়েছে।
আপনি করেছেন?
হ্যাঁ, এটা সিরিয়ালি করে একটা অ্যাটাচমেন্ট
Okay, আমাকে একটা কপি
সেটা ঠিক আছে। মানে ক্রস এক্সামিনেশন
Cross examination of
অফ
PW.
GW মানে GW2 ক্রস এক্সামিনেশন GW.
Yes.
Yes.
What is the name of PW2?
GW. নেপাল মান
Kalman.
নেপাল মান সরি property related. Yes, well,
PW2, name of PW2 is Ashok Maji.
অশোক মাঝ।
Then
ক্রস এক্সামিনেশন মানে I deal in brick business. Well, got it.
cross examination page.
DW2 but dated 11/2/2010.
Dated 11/2/2000.
11/2/2010. 11/2.
11/2/2010.
2010.
10.
10.
What are you saying?
One.
I have with cross examination of PW2 Ashok Maji. Lastly, cross examined on 10th of February 2008.
My lord.
11/2/2010, my lord. I deal in brick business.
What are you saying? There is nothing in the record.
My lord.
My lord, DW1. My lord, DW1.
What are you saying?
DW1. That is why my serially I have given my that.
What serial? I don't want. I am reading the taking the entire brief. LCR.
Yes, PW1. My lord.
PW1 or DW1 or DW2. What are you suggesting?
But PW1.
PW?
PW1.
PW.
Done. My lord, PW1. GW. Just a minute, my lord.
Adjourn, get prepared. This is not the way to conduct the second appeal.
Not only
You
one.
are not ready.
No, my lord, this is that is a serially, my lord. Just a minute, my lord. One.
You are not ready to conduct the second appeal.
Ready, my lord, that is not.
Actually, what happened, my lord, my learned senior friend made a separate seat regarding the examination and cross examination of the prosecution witness and the defense witness. My lord,
That is helpful for him, not
Yes.
helpful for this court. I have to check out the LCR.
my lord. Actually,
Then-
that is the difficulty, my lord. He has been facing, my lord.
Come with proper instruction and
My lord,
get ready. Not today.
my lord, dated 4th December 2009. One Nepal month.
So who is that?
Who is the DW?
DW?
DW.
That means you are not ready. No, not today. Forget. Let the matter be adjourned today. List the matter on 11th of April under the same heading. At least. Get ready properly.
আরে দিয়েছিলাম এটা দেখো তো সিরিয়ালি হচ্ছে না। আপনাকে
কোথায় দেন?
না
দিয়ে দিন না আমাকে এটা।
রেকর্ডে ছিল বন্ধ।
Call the list.
Grateful, my lord.
কোথায় গেল এটা? দিচ্ছে আপনার প্রশ্ন। হ্যাঁ
This matter relates to my lord, high use of the 2024 control order. Actually, heard this matter and passed an interim order. The state went to the division bench and order has been passed. Will you kindly take note of this order?
Then?
Matter has been remitted back on the ground that the point of maintainability should be considered first. If you will kindly turn to inner page 5 of the order. Paragraph 17.
Yes.
May I read, my lord? This court, this is a division bench. This court is of the view that the maintainability issue should have been conclusively decided by the learned single judge before venturing to pass any order of stay or any part of so. This is so if it is found that, the dictation is not maintainable, the interim order could cause incalculable damage to the interest of the state and consequently to the public at large, which is the second ground that this court finally in for thereafter with the interim order. Then Mala kindly come to paragraph 22. This court records that the assurance of the learned advocate
Paragraph 22.
My lord, paragraph. But
Yes.
this court records that the assurance of the learned advocate general for the state that the principle of natural justice would be duly complied with and followed while applying penalty provisions to and so. I'm pausing for a moment. Your lordship may remember, I have argued numbers of points. So far, the first point is concerned penalty part that there is no show cause proceedings, and your lordship interfere with the same. It is made clear that the state shall not be prevented from making any changes and/or amendment or modifications to the control order 2024 as it may deem fit, and proper to ensure the conformity with the similar subordinate legislature already framed in the state and other parts of the country in accordance with law. It is further made clear that the learned single judge shall proceed to hear out the petition afresh after receiving affidavits from the respective parties and pass necessary order uninfluenced by any observation made thereunder. So, my lord, thereafter the opposition has been filed. We have also filed our reply. I am filing my reply to them. I have already handed over.
The opposition has not been filed.
So, my lord, according to my understanding, they have to raise the preliminary objection first, or I can argue the case on merit, but that will not be proper to the consequence of the division bench order. Merited. My learned friend is saying that I can argue the case on merit. In that case, I can can make the sideways. Night. Sure.
My lord, I've just got the instruction, my lord. Mr. Advocate General is not today in the court, my lord. My lord, kindly please give the matter.
Okay, I understand. Honorable Division Bench has observed that the view of maintainability,
Yes,
the
my
point of maintainability has to be heard first before passing.
And
any
on that
order
ground,
of
my lord,
interim
interim
order.
order has been quashed. On that ground, sole ground,
So, before passing any interim order.
my lord.
Again, the Honorable Division Bench has observed in paragraph 22, 23,
Yes,
and
yes,
24 that
yes,
the matter can be totally hurried out.
yes, yes.
And both of the parties, you have placed the pleadings.
Opposition and reply.
Affidavit-
Pleading completed,
Affidavit in opposition in
Yes,
respect of merit of this matter.
my lord.
Entire merit, not only the point
No,
of
my-
maintainability.
Entirely.
So it is better to hear out the matter.
May I submit? Yes,
Yes.
yes.
It is better.
My
The
lord.
matter is otherwise
But-
ready.
My lord, kindly record, my lord, they have no objection. Otherwise, my lord,
Yes,
that's
yes.
because they are saying that the matter can be heard on merit. and they will argue the case merit and also point.
But in that case, my lord, Mr. Advocate General is not here today, my lord. In that case, I'll have to take instruction, my lord.
You take instruction whether we should proceed to hear out on the point of maintainability
Yes, my lord.
or in the entire point.
Including the point of maintainability,
Yeah,
including the point of.
Including the point of maintainability. Because you have placed the affidavit in opposition, including
Yes,
the
ma'am.
merit,
Yes,
entire merit you have demonstrated.
Yes,
So what, how I should proceed?
yes.
According to your instruction, I shall proceed.
Yes, my lord.
So shall I place the matter tomorrow?
Tomorrow also, Mr. Advocate
Take
General.
instruction whether we can
Yes, my
proceed.
lord. Yes, my lord.
Only
My lord.
to take instruction.
So that I can argue.
Whether we said proceed with the hearing of maintainability or the entire matter.
Yes, my lord.
If the
I shall
if the
take
point of
instruction.
maintainability has to be heard first, according to the AG, so we have to fix a date for hearing of the maintainability. Then the AG
My
has
lord.
to start first. Learned
My
AG has to
Absolutely,
start.
absolutely.
My lord.
Otherwise, Mr. Sahara has to start
My-
first regarding
I
the.
shall take instruction.
Only that instruction is important.
Yes, my lord.
Please take down. নট বলে হবে না, এটা অর্ডার আছে কি বাবা, ওইভাবে হবে না। ইনসেন্টমেন্ট যে অর্ডার আছে নোট করুন না। State respondents approach the Honorable Division Bench against the order of this court dated 12th of December 2024. Full stop. The Honorable Division Bench, in disposing the appeal being MAT 2354 of 2024, has observed that paragraph 17, paragraph 22 to 24, 22, 23 and 24 set out. Full stop. Next, in terms of direction of this court, on the earlier occasion, the state respondent has filed affidavit in opposition. Let the affidavit in opposition be kept in the record. Affidavit in reply filed on behalf of the petitioner is also taken on record. Full stop. On perusing the entire order passed by the Honorable Division Bench, it appears to me that this court can proceed to hear the matter on the point of maintainability or may hear out the matter on all points, matter on merit, including the point of maintainability. Full stop. Next, it appears that the affidavit in opposition placed by the respondent number 1 to 5 has pointed out the entire merits of the matter, including the points of maintainability. At this juncture, it is the option of the state respondent. They may proceed to raise the point of maintainability, or they proceed to hear out the, or they proceed to argue on the point of law, on the on merit, argue on point of merit. Learned counsel appearing on behalf of the state authority seeks accommodation for proper instruction. According to the matter be adjourned today. List the matter tomorrow under the same heading for instruction, seeking instruction on behalf of the respondent.
Yes.
The 11, 16 and 17, three matters, my lord. I am a little bit difficulty. My advocate and record is not in court. Is it possible, my lord, to fix it tomorrow? Well, subject to my lord, my learned senior
11, 16 and 17.
17. My learned senior is here, my lord.
Okay, 3 matters are there.
Yes, 2 I have filed writ petition, 1 by my learned senior.
You are seeking for an interim order on that on your matter.
I want interim order.
So come on tomorrow. He is on difficulty. So come on
But
tomorrow.
the advocate on record is not today, my lord.
Tomorrow
Day after tomorrow, my lord.
Day after tomorrow.
Day
at
after.
your wish.
Day after tomorrow.
Day after tomorrow. Very well.
And meanwhile, my lord, the sister of my lord, the brother, those who are aspirant to be the my lord, the fair price shop dealer, my lord filed one application, CAN application. In their my lord writ application, my lord said certain allegation have been made by them. My lord, they are consent.
Why are you moving this matter? Let them move the matter.
Yes, my lord. Deeply.
Let them move the matter.
Deeply. Deeply.
11, 16 and 17.
No,
Day after tomorrow.
16, 17, 11. 11, 16.
একসঙ্গে দেবেন 11, 16 and 17. Next.
I am for the Union of India, lead by Saini Roy Chaudhary. Hearing for the Youth Commissioner.
This matter appears for correction in the order dated 29th of January 2025. The writ petition number was erroneously mentioned as 17798 of 2024. It should be read as 17798 of 2023. The remaining portion of the order should be unaltered. Remain unaltered. This portion of the order would remain unaltered. One is that next. Next.
This is a case where my lord, a dead person has been added as respondent on last occasion, your lordship directed. Can you see the order dated 19th of February 2025? No affidavit has been filed, name has not been expunged. Possibly they are not. This is the case where I have submitted before lordship cause of action of 2007. May I hand over the order?
On record দিয়েছেন
Badal Das. Badal Das. The last order 19th February 2025.
Yes. What is the application?
Nothing. I am for the respondent.
You are for the respondent. Okay.
I have raised the point of maintainability on last occasion that a cause of action of 2007 and writ petition has been filed against my husband who died.
Who is for the petitioner?
Uh,
Mr. Osini Kumar Bera. Arijit Bera. Where are they?
and no affidavit and application has been filed. Possibly lost their interest. Let it go out of list liberty to mention.
Yes. One respondent expired.
Yes, and entire allegation is against him. They have sought for cancellation of the license of my deceased husband by giving the number of the license. Thereafter, I got the license.
That is Sadhan Dandapur.
My lord.
Very well. Please take down. Mr. Sahara appears on behalf of the respondent number 8. None appears on behalf of the petitioner. Full stop. On the earlier occasion, the petitioner was directed to take appropriate step regarding expunging the name of one deceased respondent. No steps has been taken. Considering the conduct of the petitioner, let the matter go out of the list. Party has liberty to mention.
Well, get rid.
Next.
15. I am for the petitioner. My lord, Mr. Jungal Bhattacharya is assisting me. Okay. Day after tomorrow. Take it with take
Not
it after
today.
day after tomorrow.
Day after tomorrow.
Wednesday.
Mr. Bhattacharya is not there.
Not there. He's out of station.
Okay, what can we do?
So I'm not opposing this kind of a prayer.
Never.
Okay, day after tomorrow.
I'm the prayer.
Next.
I'm for the state respondents, my lord.
Assigned matter.
Yes, yes, my lord.
Why it is assigned to me?
So it was with justice, my lord. Partha Sardasian, he lords only passed the ground, my lord, release the matter.
Petitioner only respondent.
This is a writ petition.
Yes.
Abolition of displaced person and eviction of person. Who is for the petitioner?
I am for the petition.
You are for the petitioner. Whether the pleadings are complete?
Yes, yes, my lord.
You have placed the written.
Page 56 is the, my lord, MP note, my lord. Page 56.
Let me hear out the petitioner first.
Well, I am for the respondent.
You are for the respondent?
6.
Respondent number 6. You are the state respondent.
I have allowed Mr. Jayanto Samantant.
You are along with Jayanto Samant.
Yes, madam.
So where is the writ petition? So affidavit in opposition on behalf of 5, 6, and 7.
Well, actually, my lord, the change.
Government has not used any affidavit.
No, no,
You are for the respondent number?
6.
There is a joint affidavit in opposition 5, 6, and 7.
My lord, 6 and 7. 3 of them are the same family member. They are the brothers. One of them has given.
I wanted to know whether there is a joint
No, he has
affidavit.
filed on behalf of 5, 6, and 7 private respondents.
5, 6, and 7.
5 died. Thereafter, my lord, his wife was actually substituted.
Very well.
No,
No, let me just understand the brief first. Thereafter, I will take up the matter. Where is the impugn order?
Page 56, my lord.
Page
56.
Before that, well, also kindly make me permission in my own way. Well,
Yes,
Your Lordship has
yes,
seen-
I will give you. Let me just check it out the entire file. Thereafter, I will give you the entire scope to argue the matter
Page
on
50
your way.
Page 55, the impugned order. Annexure P. The order is in order is page 56.
Very good. Yes, proceed.
Lord, government has issued an order.
Yes.
A guideline for settlement of permanent who was refugee, who from East Pakistan has come to India. They are settled in different parts, and there are colonies, some colonies. This is a colony land. The petitioner's father and the petitioners came long ago. Thereafter, they are residing at the place which is subject matter of challenge in this case. And respondent number
Father of the petitioner came from East Pakistan and settled here.
And stayed here in a colony.
Settled here in a colony by an order of settlement.
For order of settlement. I am coming to that. And the government order, first of all, your lordship, if you kindly see the government order.
Yes, yes.
Government order is very clear. At page, this is the guideline, page 45 of your lordship brief. Page 45, and it's at P2.
Page 45 is the government order.
But in merit petition.
Yes.
Government of West Bengal Refugee Rehabilitation Department, so and so. Subject. Has your lordship got it?
Yes.
For implementation of the scheme for confirmation of right and title of refugees in the urban area of West Bengal. The government of West Bengal in Refugee Rehabilitation Department issued government order bearing number so and so 10th November 1986 declaring the decisions to give freehold and permanent title deed to the occupant. Well, this is very important. Occupant who are residing in the place, they are occupant of the government owned vested khas land so and so, so and so. Thereafter also the government decided to confirm similar refugee holder freehold title and freehold right and title to the dependent persons in the urban area or in the occupation. It is also who are in the occupation of the land. That is very important. Thereafter, logically, for paragraph 2,
Similar freehold right title to the displaced
freehold title deed. Government will issue freehold title deed to the persons who are residing in the colony area who came from East Pakistan to West Bengal. Sorry, India. The circular paragraph 2 in the circumstances mentioned above, the undersigned is to direct to say that the government is pleased to direct that the right and title to the plot of urban CS plot numbers quarterland colony to be confirmed on different places so and so. But the guidelines 1, 2, 3, 4, 5, I, A, B, C, D, these are the criteria. ये गला को दे दे ভুলে গেছি
Yes.
Yes. Then logically see these are the guys. Next page, which is very important.
So colonies are categorized in 5 ways.
Categories, that's right. Next page 46.
Page 46.
Page 46.
Yes.
The for the purpose of second paragraph, for the purpose of grant of freehold right and title in different urban colonies, 4 different types of deeds are now prescribed as decided. So these are the 4 types of A, whether 1, 2, 3, 4 types of.
So these 4 types of deeds are prescribed.
Prescribed. Well, 4
to grant freehold right title.
Yes, to grant by title. Well, next II after 4.
Yes.
This is very important. In terms of the existing, as you also got it, II. In terms of the existing government policy, freehold right and title deed may be executed only in favor of the dependent, displaced persons from erstwhile East Pakistan, now Bangladesh, who is in effective possession. Well, this is very important, but so far my knowledge. Who are in actual possession of the land, they are entitled to get freehold.
Yes.
Yes. So then logically she come to just long way. Next page. All criteria are settled.
Yes. Next.
Next page 47. Third paragraph. VII.
Roman 7. Yes.
Flip over all these. If the land or a portion of it, as the Lord got it, portion of it received from the government leaseholder, basis on
government on lease.
Yes, from government on lease.
On leasehold.
Hold.
Basis
in found to have undergone any transfer without prior permission of the government.
Yes.
Conversion of two leasehold of the leasehold into the freehold deed should not be allotted without prior clearance from the government. That is means, my lord, nobody who has been settled with the land should not be transferred to any persons without the prior permission of the government. This is the basis. Well, these 2 things are necessary for disposal of this application. Well, you logically come to my paragraphs, some paragraphs are necessary for the purpose of this or the annexures. I have annexed all these things necessary for the purpose of determination of the Annexure P2, page 27. Has you also got it?
Yes.
This is a ration card. Granted to Gautam Court that the petitioner before your lordship on 11 February 1974. Next page. This is not denied in the affidavit in opposition. Next page. Well, this is 151 Thakuria Assembly Constituency Roll number 1988. In this, well, second paragraph, 6 to 6, 7, 8, 6, 7, 8, and 9. Premises number 132.
Yes.
You also got it. This is Milon Dotto Milon. Milon Dotto is respondent number 5 here. Who died there? Thereafter, Dotto Somita, wife of Milon. দত্ত ইভা ইভা
Ivalota.
Ivalota, the mother of Milan Dotto, Kolkata. Well, then his name has appeared in the electoral roll in 1988 at page premises number 2132.
Yes.
Yes. This is at the top, Vidyasagar Upasana from the Calcutta Municipal Corporation, then Vidyasagar Upanivesh. As you lordship got it, Vidyasagar Upanivesh, premises number 132. North Mellor at Eden Bose Road. 11H Eden Bose Road is the disputed plot at Calcutta 4040, but he resides at Mellor. Upasana Vidyasagar Upanivesh.
Who resides?
That is restaurant number 5. Dr. Milan is the restaurant number 5, and his wife and
Very
father.
well.
Other 7 and
in premises number 132.
yes. Then you
Milan Dotto. Milan Dotto.
Milan Dotto.
Very well.
Then when on next page, page 29, it is in the Dhakuria Assembly Constituency Roll, 1988. The left-hand side from top, 5th line. 1615, serial number 1615, premises number 132. Here is also 132. Why I am placing here Lordship's Mellor? He is not residing at 11A Edinburgh Road. Here also Vidyasagar Colony at the top. This is not denied. Next page 30. Can you see next page 30? 1, 2, 3, 4. 960. Serial number 960. From top 5/5. (960) call Gautam. Premises number 11C, where the NN Ghosh Road, Narendranath Ghosh Road. This is the subject matter of the land on which the petitioner has been residing for long ago. Your Lordship has seen the Vidyasagar Upasana, and here the petitioner is residing, it appears from the roll, electoral roll, Narendranath Ghosh Lane.
Yes.
Then your logically comes, flip over some of the pages. Page number 32. This is also third block. Gautam Kaur. From the left side, from top third, 1, 2, 3, third number. 819, third block.
Yes.
Lordship got it. Next, logical. Lord, my submission is that the respondent number 5, 6, and 7, they are not residing at NN Bose Road. They are residing with Vidyasagar Upasana. For your Lordship and consideration, I have placed all these things. Next page. Next page, page number 33. This is a certificate issued by the Legislative Assembly, Mellor Hantasu, MLA. This is to certify that Sri Gautam Kaur of Chandpur Colony 11H, well, this is marked, logical mark it. 11H is the subject matter of challenge in this writ petition. N.N. Goslow, Narendranath Ghosh Lane, Calcutta 40, is known to me. This certificate was issued by Prashant Chud, did an MLA, Member of Legislative Assembly, West Bengal, on 13/3/1979. Next page below, this is also page 34, Prashanta Banerjee, a Pankaj Banerjee, he is a member of the Legislative Assembly, West Bengal. He has also certified that Sri Gautam Kaur of 11H N.N. Ghosh Lane, Calcutta 40, is personally known to me, who is an eminent doctor, dentist, who has undertaken many so and so, we are not concerned about that. This is issued on 1st of June 1998. Then next annexure, page 53. This is also a certificate from the councillor of the Calcutta Corporation, certified that the Gautam Kaur so and so of 11H N.N. Ghosh Lane. All these certificates. Next annexure is also my submission is that the petitioner is residing at 11H N.N. Ghosh Lane, Narendranath Ghosh Lane, Calcutta 40. This has not been denied in the affidavit in opposition.
Yes.
Yes, my lord, next page. Page number 37. My lord, this is a tax bill issued by the Calcutta Corporation in favor of Milan Dotto. Lordship owner address Milan Dotto, C10 Purbo Diganto, Santoshpur. I have made them party in the writ petition addressing them as C10 Purbo Diganto. This is not denied. In paragraph 6, not denied by in the affidavit opposition. Now he is claiming he is residing in 11H N.N. Ghosh Lane.
Who? Milan Kumar Datta.
Milan Datta. But all these things has not been denied. The corporation has issued tax bill in respect of a premises at C10 Purbo Diganta Santoshpur, Calcutta 75, not 40. This has not been denied. Next, Lordship kindly keep over this. The Milan Datta has been trying to occupy the land. Thereafter, the complaint was lodged by Gautam Datta, and Lordship kindly he was at that time in Kashmir as a military person, junior commission. The page 41. Page 41, annexure 9, copy of the Union Home Minister's letter number so and so, dated 9th of June 83, addressed to the chief ministers of all states and union territories. It has been issued. The military person should be protected by the police in respect of their land. So that was the total sum and substance of this letter. Page 41. This has not also been denied.
So Gautam Kaur is a military person. Military person.
No. Gautam Kaur is a military person.
Gautam Kaur is a military person.
Gautam Kaur is the petitioner before your lordship.
He is the army man.
Yes. I just show the next document. Colonial commander has issued a letter to the commissioners of our department, page 45. Page 45. Dear sir, with reference to the letter number so and so, so far no information from your a letter was issued to the commissioner, our department.
Whether Gautam Kaur was a dentist or the military person.
Gautam Kaur was the military person, a junior commissioner as a doctor, dentist. Thereafter he retired. Now he.
So what you want to submit?
Page 42.
Yes.
Page 42. This is the letter issued by A.P. Pal, Colonial Commander, to the Commissioner, our department, so and so. As per Law Land Control Act number 18 1986 for armed force personnel of India, now so and so, under Ministry of the Home Department, so and so, that none can occupy the army personnel occupied land. Because the respondent number 5 was trying to occupy the land. So this letter was issued to the Commissioner of Police. And this is also forwarded to the Superintendent of Police, 24 Parganas, OC Region Park Police. Next document is the similar document, page 43.
I cannot read it. What is the next document?
Yes. This is not denied in the affidavit of opposition by the respondent number 5. Paragraph 2, so and so, Gautam Kaur of this unit has submitted application against.
You are reading page
43, 43.
I cannot read it.
Legible.
Not legible. What is this?
Yes. Well, this is also written by the commanding officer to the district magistrate, South 24 Parganas. Well, Gautam Kaur is residing at 11A Eden Ghosh Road. There, the respondent number 5 and their associates was trying to occupy that portion. So he made an application with the different person. The colonial, the commissioner issued a letter to the district magistrate to protect them under the law. That I have placed your lordship.
Yes.
She should not be disturbed in position. These are the letters. I am placing all these letters. Then, lordship, your lordship has seen 45 days guideline. Keep about this.
45 days is the geo.
45 is a guideline.
Guideline, yes.
Thereafter, 48, I made a demand of justice to the commissioner, page 48. Demand of justice, commissioners and deputy commissioners, deputy director, department, so and so. That representation was not considered by the authority. So, the petitioner Gautam Kaur made an application before this honorable court. That is page 51.
Yes.
My lord. Look, Dean Justice Dipankar Datta was free to pass this order, directing the ordering portion is at page 53.
Yes.
This case was not controverted or denied by the respondent number 567, though they are party to the case. The petitioners is aggrieved by the inaction of the respondents in considering the notice demanding just related so-and-so sent to them by his learned advocate. Having heard learned counsels for the petitioner, this court is of view that regard being had to the nature of the controversy raised in the petitions is useful purpose. No useful purpose will be served in keeping the is pending, and the same may be disposed of by reason order, by passing necessary directions. Accordingly, this petition stands disposed of with the directions of the commissioners, respondent number 2, to consider and dispose of the said notice demanding justice in accordance with law, giving upon granting the petitioners and the others persons who be considered necessary to be heard this report, and the opportunity hearing should be given so and so within 6 weeks. But 6 weeks, within 6 weeks, no order was passed. Next, page 54, till considering this notice demanding justice as directed above, the party to the proceedings shall maintain status quo as regards position of this case. Thereafter, the impugned order was passed. Page 55. Your Lordship kindly show page 55. This is intermittent to petitioners Gautam Court and also the Lord Milan Datta. Will also kindly see. 2. This is very important. See Gautam Court 11A at page 55 of my brief. Have you not got it?
Yes.
2. Sri Gautam Court 11A Narendranath Ghosh Land, who is the subject matter of challenge in this case. Next, 2. Sri Milan Kanti Datta, C10 Purva Diganto. It is apparent from the face of the record that the respondent number 5, Milan Datta, was residing at C10 Purva Diganto. I have shown your Lordship previously the role, assembly election rule, and other things. All these things, from all these things, it appeared that he was residing at C10 Purva Diganto, Narendranagar, PS Purva Jadavpur, Kolkata 75, not 40. 40 is the place where the petitioner is residing. Then, my lord, the order was passed. My learned friend, I shall, may I am.
Okay, just sit. Sit down. Please sit
My
down.
learned friend is present.
Yes. You sit down, please.
I am very sorry to appear because
No, you just sit down and see the proceeding just. You just wait. Take
I
rest.
am
No
now
issue.
86.
No issue, just take rest. Yes, proceed.
The order passed on 21st October 2008. The petitioner Sri Gautam Kaur
Take the mic. Take the mic.
and respondent number 5 Sri Milan Kanti Datta filed Hajira in compliance with the directive as contained in the order dated 1st August 2007 passed by the Honorable Mr. Justice Dipankar Datta in writ petition number 4428 W of 2007 in the High Court at Calcutta. The petitioner and the respondent number 5 were directed to appear before me the Refugee Rehabilitation Commissioner on 21st October 2008 for a hearing. The petitioner Sri Gautam Kaur stated that his advocate could not be present during the hearing as he was otherwise engaged in the Honorable High Court, and when it was pointed out that the Honorable High Court was then on vacation, he further said that his advocate was ill. The respondent number finds Sri Milankanti Datto was represented through his advocate. I have gone through the writ application of the petitioner along with all annexures. The present writ petition has been filed by the petitioner praying for appropriate relief by means of freehold title deed in his favor in respect of 03 kata, 05 kata, 40 square feet of land comprised in SP number 11 and 12A of Chandrapur Colony 1, PS Regent Park, Calcutta 40. It appears from the office records that a freehold title deed was issued in favor of Sri Milankanti Datto, respondent number 5, in respect of SP number 11 for a quantum of land measuring 02 kata 33 square feet. Height being numbered 1980 registered deed on 21st September 19. Sri Manoranjan Kaur, now deceased. The petitioner's father is recorded as the occupier of SP number 12, measuring 03 kata, 12 kata, 00 square feet. There is, however, no record of any occupier in respect of SP number 12A, measuring 01 kata, 05 kata, 07 square feet. The two plots height SP number 12 and 12A are noted as joint plot. No freehold title deed has yet been issued in respect of SP numbers 12 and 12A. The petitioner claimed that having possessed the piece of land measuring 03 kata, 05 chatak, 40 square feet for 4 years together as a refugee, he is entitled to get freehold title deed in respect of the said land, SP number 11 and 12A, taken together. The submission of the petitioner and the learned lawyer for the respondent number 5 are heard and considered. In consideration of office record, the refugee submission of the respondent number 5 and as also the fact that the petitioner Sri Gautam Kaur is now in possession of recent the plot SP number 12A measuring 01 kata, 05 chatak, 00 square feet. It is my considered opinion that freehold title deed in respect of the said plot may be granted in favor of the petitioner Sri Gautam Kaur, subject to his proving to the satisfaction to the competent authority that he is a legal heir of a bona fide refugee. The matter is thus disposed of.
Yes. So why you are aggrieved?
Then yes, I am coming to that one. Lordship, kindly see the next annexure, page 61. Annexure P17.
Yes.
Page 1. This is addressed to Milan Kanti Datta so and so. No address. It is a very clever officer that without giving any address, they have sent a letter. The undersigned has to direct to inform him that an office team headed by so and so from this stage will go to SP 11 of Chandpur colony for arranging the delivery. Your Lordship, kindly mark it. For delivery. He is not deciding there, but he has to deliver the position. He has to give the position of the land. I shall say. He is residing at C10 Purbo Diganto, Milan Kanti Datto. delivery of physical possession. Has your lordship got it? Page 61.
Yes.
Page 61, logically for a moment, my lord. I'm placing that. The undersigned is directed to inform him that an office team headed by so and so from this office will go to SP 11 of Chandpur colony for arranging the delivery of physical possession of the said land on so and so in favor of Milan Kandi Dotto.
No, this is a letter of 1990.
No, this is a letter, officer in charge who has informed to Milan Dotto, page 61, logically.
Yes, this is a letter of 1990. This is a letter of 1990.
That's right.
Yes.
The case was thereafter. 1919. 1990.
No, you have not challenged the letter?
Yeah, I have challenged that. I have challenged, so I have made annexure.
No, have you challenged the letter?
Yes.
No, perhaps you have not challenged. In your
logically, see this letter, thereafter I shall try to satisfy your lordship.
I have seen the letter. Yes, proceed.
Yes. Well, this is written officer in charge soon. What I am trying to submit for delivery of physical possession, this letter was issued. A office team will go and for delivery of physical possession to Milan Kotto. It is apparent from the face of the record that Milan Dotto is not in possession of this plot. For delivery of possession, a office team will go. Next, logical issue. Thereafter, a demand of justice was made. Well, a representation was made to the secretary by the petitioner. Well, why?
No, demand of justice of what?
Well, this is a letter, this is representation. This is a representation
against the letter dated 22nd of August 1990.
Yes, yes.
So, in the year 1991,
that was
passed and you have
in practice.
raised the demand of justice in the year
That was
2008.
not in practice. Thereafter, I have made a petition. In practice, none go. Nobody restart. How can I know? Well, I am asking myself.
No,
The letter was issued, but no team has gone.
No. You just let me just understand your content, sir. You are confusing this code. One, you have.
No, I am not. I'm not
understand.
clear. I am not clear before your lordship.
Yes, let me understand.
Well, that's
So, Justice Dipango Datta has passed an order.
yes.
One region order was passed by the authority. You challenge the region order in the writ petition. Now, you have placed one letter dated 1990.
Well, when Dipankar Datta passed this order, logically see again.
Yes. After the letter was passed. It is 1990 letter. A separate cause of action is there.
Para 23.
Yes.
Huh? In the writ petition, kindly see para 23.
Para 23.
23. Thank you. The officer in charge development attached to the office of the Refugee Rehabilitation Commission issued a letter Milan Datta without proper address, white number so and so, dated 22nd of August 1990, intimating inter alia that the office team headed by X so and so would go to SP colony physical possession of the author that then logically see. It is crystal clear from this document mentioned in the above that the Milan Dotto was never in physical possession of the said land and the said deed of gift he has been living in a different place even at the time of executions of the deed of gift 1990. Inasmuch as the said letter was issued by our department without mentioning any address and everything had been done with an utter ulterior motive and for collateral purpose.
Now, why you not place this matter before the court?
No. This was not served on me.
No,
My
not served
subject
upon me.
matter.
I understand it was not
No,
served upon me.
This
Upon you,
letter,
but
this letter
why
was
you not
issued
place
later
the
on.
matter before this court?
No, this
on the
letter
earlier
was
occasion?
issued later on. After Justice Dotto's order, this letter was issued. 19, Dotto, my Lord Justice Dotto passed order when? Logically, again. In 2007.
Yes, 2007 is the order, and you are placing the deed letter of 1990.
That's right.
Then?
Because at that point of time, my Lord, my representation, you logically consider my representation. At that point of time, on the basis of which Justice Dotto was pleased to pass the order. What is my demand of justice?
In your representation, in your earlier
Page
representation,
48.
Have you mentioned about the letter?
I have mentioned.
No, you have not mentioned the letter.
I have not been served, perhaps, my Lord.
Whatever, maybe you have not mentioned the letter.
This was not my knowledge. I have not been served. Let them produce the record whether I have been served. If I have not been served, how can I know this order was not
No, that is not the way to appear before the read court.
Perhaps
In the year 1990, one letter, you just take out a letter.
I have demanded justice on 19th of February, page 48. Can you see? On the basis of this demand of justice, Justice Dotto was pleased to pass towards 2008. This letter, this has not been considered by the consular, by the commissioner.
Which letter?
Well, 1990, they have given a issue.
You have not placed the letter before the commissioner also. Have you placed the letter before the commissioner at the time of recent order? No, you have not placed.
57. Reason order.
Yes, 57 is the 56, 57 is the order. You have not placed the letter of 1990 before the commissioner also. Now, how you are mixing the matters?
Well, before that, I was not informed. I was not aware of this order. Here, logically, last page, last paragraph, page 57, it appears from the office record that a freehold title deed was issued in favor of the Milan Kanti Dotto, respondent number 5, in respect of SPH number 11 for a quantum of land measuring 2.2 kata, 36 square feet, file number so and so, on 21st of September 1990. হ্যাঁ এই অর্ডারটা পাস হওয়ার after passing this order I came to know. Then I came before this honorable court and my Lord Justice Dipankar Dotto asked me to direct you consider all these things.
No, that is not the case. That is not the case.
আমি সেটাই বলছি after considering the judgment of my Lord Justice Dotto, they have considered this matter. Before that, I was not aware of this fact. How can I tell him? After passing order by the decision order, I have challenged this petition. Before that, I was not aware of that order. Let them say so. They have not denied. The authority below respondents below state respondents has not used any affidavit opposition denying all these things. So that is acceptable. They cannot challenge it. That has been accepted. In view of the Supreme Court judgment 19A 1990, judgment বলতে পারি 1990 না এটা লেখা নেই না না এটা
Have you got the letter? Have you got the letter 1990? Have you received the letter? Who gave you the letter? Yes.
After Justice Dipankar Datta was free to direct to consider the thing, the representation. That representation should be considered in accordance with law. Well, that order was passed on 2007.
I have seen that order.
Justice order.
I have seen that order.
Yes. My submission before your lordship. Before that, I was not aware of this order. Let them produce. I have been served. Let the state respondents produce. They have not used. They have not denied. I have not been served. After serving this, below the region order was passed, and
The
I
state
appeared.
respondent is of opinion by the region order. So far as I came to know that by the region order, your father was in possession of 12 and 12A.
Yes. No. From the documents I have shown your lordship that I am in possession of 11A. All these documents, certificates, and all the
Very well. So what is your grievance? So what is your grievance here? You are not challenging the region order actually. Are you challenging the region order?
Yes, brother. Logically, see my prayer.
Challenging the region order?
Yes, logically.
But you have not challenged the letter.
62. 62 is your representation by the page 62.
Whether you have challenged the reason or letter dated.
Well, logically, see my prayer.
Yes. It is better to go to the prayer. You have not challenged the letter 1990.
Page 21.
Yes.
To issue a writ in the nature of mandamus, commending the respondent to forbear from giving any effect and further effect to the said deed of gift so and so in favor of the respondent number 5, and the impugned order dated so and so, signed by the respondent number 2, on dated so and so being annexed at 51. Page 15. Annexed at 15. Within such time as may be prescribed by this honorable court and seen revoke and cancel them all. Thereafter, annexed prayer B, to issue a writ in the nature of mandamus, commending the respondent's number to grant freehold right and permanent title deed to the petitioners in respect of SPA and SP 12/A, both the bed of the Chandpur sector colony number 1, Narendranath Ghosh Lane, Kolkata, say 40, T.S. Region Park, District Southwest Kolkata, measuring a total of 3 kathas, 5 kathas, 40 square feet. To issue a writ in the nature of mandamus directing the respondents to transmit and to certify the record of the case within such time, including the deed of gift, dated so and so in favor of the number 8, And the impugn order dated.
Where is the deed of gift?
Page,
What
page,
deed of gift?
page 22, page 22.
Page 22 is the deed of gift.
Prayer C.
No, what is the deed of gift you are stating about the praying
Deed
about?
of gift, they have issued
What deed of gift?
in favor of respondent number 8A5.
Where is the deed of gift?
Page 60, possession should be given.
Page
60.
That is not deed of gift. Letter of allotment.
Letter of allotment.
This is not deed of gift.
No. Deed of gift.
So where is the deed of gift?
Allotment. I don't know.
Then why are you
Deed of
stating
gift
about
in
the
their
deed
favor.
regarding deed of gift?
I'm coming to that, Milord, from the affidavit. Logically, from the affidavit, I shall place something for your lordship consideration. Logically, it's affidavit in opposition filed by thee. They have not. Are
Affidavit in opposition by the respondent of 5, 6, and 7.
My lord, Mr. Samant has come here. Shortcut the matter, my lord. It will take 2 or 3 minutes.
Let me just give the opportunity. Let him apprise the court. Otherwise, it is not possible. Yes, affidavit of opposition by respondent number.
I have not annexed the deed of gift. No, I have challenged the deed of gift. I have challenged the deed of gift without annexing. No, logically, see there affidavit in opposition, some paragraph. It has been mentioned in the reason order, deed of gift has been issued.
In the
deed of gift in favor of respondent 5 has been issued.
Where it was mentioned?
Because in the reason order, it has been placed. It appears from the reason order passed by the commissioner.
No, the title deed. It said about the title deed. Very well. Anything further to say?
এটা তো ওরা পাঠিয়েছে সেই ওরাটা এখানে নেক্সট পেজটা ওরাটা নেক্সট পেজে ওরাতে কোথায় বলেছে
In the region order, it was stated that the freehold title deed was executed in favor of Milan Datta.
57 last paragraph. It appears from the office record.
Yes.
That a freehold title
deed, not gift.
No, title deed. Well, this is the title deed. Government will issue below freehold title deed. This is the title deed means without any remuneration, without any amount from the person who came from East Pakistan to India. They are living in a separate place. That land should be given and freehold without any consideration by the government. That all. This title deed means, my lord, they have been issued title deed. Not gift. The gift means it's a gift also, because without any remuneration, without any value of the land, a gift was given. That was
no, that is not a gift.
No,
not
that is
a
not
gift
a gift.
by the state.
I am not saying that.
No, you have stated in the prayer.
Deed,
that's why I am asking whether any deed of gift.
Title deed, in the government order.
This is a deed of settlement. This is a deed of settlement by the government.
Yes.
This is not a deed of gift.
No.
Government has not empowered to gift anyone.
No. In the circular, it has been stated that a deed of settlement, deed of gift will be.
So government shall issue freehold title deed.
Freehold title
in favor of the refusee.
My lord.
In the colony.
Logically, affidavit in opposition filed by the petitioner.
Filed by the
filed by respondent number 5. Actually, respondent number 5, 6, and 7.
Yes, refer me the
This
paragraph.
has been affirmed by Shankar Datta, respondent number 2. Page 4 of the PTPT deposition. Page 3 also can see A, that 1 Milan Datta, respondent number 5 herein, is the elder brother with the respondent number 6 and 7. And respondent number 5 was a bona fide refugee from East Pakistan, now Bangladesh and so, along with the family members, including the mother and two brothers. It is relevant from the state of the respondent number 5 was a bachelor throughout the year. This is the statement made on oath that Milan Datta was a bachelor. But by the order of this court, after his demise, his wife was substituted also 5A. Also kind read the order. After serving notice to everything, she had received the notice. Thereafter, after demise of respondent number 5, Milan Datta, his wife was substituted. But his brother is affirmed this rule that he was a bachelor. এটা কি আমার? আমারটা কোথায়? তাই হোক।
Yes.
Page 3, paragraph 1, A. Bachelor. Next, section. C. I state that in 1948, the respondent number 6 and 7, being younger brother of the respondent number 5, were only aged about 3 or 4 years. As minors, they were fully dependent upon the respondent number 5 to construct a dwelling house on the said plot, hearing number so and so. Next page. I further state that all the material times since 1948 till date, the respondent number 5 along with the respondent number 6 and 7 and his other family members are enjoying the said plot, including passage number so and so, and this is the summary statement. I have shown your lordship not try to show my lord. They have been, the notice was issued by the concerned authority to give them physical position. It implies that he was not in position. Then logical issue. Page 7. I. Towards furtherance of the policy of the state, to its refugee relief and rehabilitation department duly executed a registered deed of gift in favor of the respondent number 5 in respect of plot number 11H, Narendra Ghosh Road. Next also, said deed of gift was registered on September 21, 1990, being number so and so, book number, registration number 1980, recorded in book number what, volume number so and so and so and so, but in the additional district sub-register Alipur, number 3. Next, I state that the respondent number 5 possessed the said land, said plot of long further, 14 years. Thereafter being a bachelor, here is also he has been stated as respondent number 5 is bachelor, out of the natural love and affection, executed a registered deed of gift. Number so and so in 2004 in favor of the respondent number 6 and 7. I have shown your lordship that without the prior permission of the authority, a transfer could not be made by any settlement. But it appears from the statements made by the respondent number 5, 6, 7 that the transfer deed was issued in favor by the respondent number 5 in favor of the respondent number 6.
So you can challenge it. You can challenge it.
Well, how can I know? I'm
Okay,
asking
okay,
myself.
you can understand
Whether
that this matter appears after filing the writ petition.
Yes.
So you can challenge not in this writ.
After filing the writ
You can
petition
challenge
1980 to 2008, they have filed this affidavit in the opposition.
You are allowed to challenge according to the law in respect of that deed. So this is out of the ambit of this writ petition.
I am asking myself, after filing the writ petition in 2008, they have used this affidavit in the opposition. I have given reply. All these things to be considered by your lordship. What I am placing, my lord, he has stated on oath that respondent number 5 was a bachelor. If a person makes false affidavit and mislead this court, the Supreme Court has passed, had the occasion to consider that
there is a specific provision of law for making false affidavit before a court of law. You know that.
My lord.
There is a specific provision to challenge the affidavit, false affidavit before a court of law by taking applications
yes.
before a competent court of law.
What I am trying to submit to your lordship that he has stated on oath. I am repeating. In that affidavit should be considered by this court. That whether he has made any false or frivolous allegation, or that should be considered by this law.
Very well.
Well, thereafter, my lord, what you can see. Page 11, paragraph 5, it has been stated that the mother of the respondents died on 13th February 2008.
Okay, anything further? Yes.
আর কিছু বলবেন?
No.
Very well.
My lord, I beg to appear on behalf of the state respondent, my lord.
Yes.
But in my school days or the law school days, my lord, we have learned a maxim verbis legis non est residendum, which mean, my lord, the everything to be read as a whole, not as a part. Lord, I start from the prayer portion. The Lordship is well aware of the fact, my lord, when a writ petition or a petition or an application is considered, the foundation of the same will be the prayer. Prayer is the guiding factor or a guiding compass. Well, kindly come to page 21. Prayer A, my lord. I'm reading for your lordship, my lord. To issue a writ in the nature of mandamus, commanding the respondents to forbear from giving any effect and or further effect to the said deed of gift dated 21st/9/1990 in favor of the respondent number 5 and the impugned order dated 21/10/2008 signed by the respondent number 2 on 18/11/2008 being the annexed P15 within such time as may be prescribed by this honorable court and rescind, revoke and cancel them all. Well, I'm pausing here for a moment, my lord. Kindly consider this prayer contains two parts. First, my learned friend has prayed for cancellation of deed of gift. In absence, your lordship has seen the absence of any deed of gift. This prayer, the first portion, become non-est. And even if, my lord, I presume, if there is a deed of gift, but that is to be considered by the concerned court, by the jurisdictional court. The writ court perhaps do not empower with that. And the second portion, my lord, the impugned order dated 21/2008. Your lordship will find it in page number 56. That is the operating portion starts from page number 59.
Yes.
The matter can be cut short here. The after passing of the order by Honorable Justice Dipango Datta, the department was directed to pass a reasoned order considering all the factors. Department consider all the factors. And my lord, in the meantime, my learned friend suggests that some documents have been received by him. But here kindly consider when a executing court executes a degree, it cannot travel or must not travel beyond the degree passed. Here, my lord, same proposition perhaps will apply that when an order has been passed by a writ court, considering all aspects, the other documents which came forward after passing of this order, that to be considered separately by separate institution of separate proceeding, not by continuation of the proceeding or a proceeding which challenge the impugned order or the order passed by the department in connection with the writ petition. Look, the page 59 says, in consideration of the, has your lordship got it, my lord?
Yes.
In consideration of the office record, the submission of the respondent number 5 and also the fact that the petitioner Shri Gautam Kaur is now in possession of RR plot number 12A, SP 12A measuring about 1 quota 5 seater 0 square feet. It is my considered opinion that freehold title deed in respect of the said plot may be granted in favor of the petitioner Gautam Kaur subject to his providing to the satisfaction of the competent authority that he is a legal heir of the bona fide refugee. But the department have never said that your prayer is rejected, your prayer is abandoned, it is turned down. Not. You have given a scope that you provide this and we can be able to give you the as per the relief as per the RR was directed by this honorable court. But pausing here, kindly consider this writ petition would perhaps not file and your lordship's precious time would not have been wasted if the petitioner pursued this order. Lord, by what he has been directed, it is my considered opinion that freehold title deed in respect of the said plot may be granted in favor of the petitioner, the Sri Gautam Kaur, subject to his providing to the satisfaction of the competent authority that he is a legal heir of the bona fide refugee. If this would have been filed before the authority, then my lord, the authority would be in a position to consider the case of the petitioner in his potential satisfaction. Otherwise, my lord, whatever I am submitting, my learned friend is submitting before lordship, it's a perhaps wasting of judicial time because the authority has not come to a conclusive finding. It's depending upon his filing the application, proving that he is the actual legal heir of the erstwhile or the original refugee who was allotted with the RR plots. Unless until that is there, the department cannot know my lord, who is there and who will substitute him and who will come into the light.
Yes.
But this much only. And I believe, my lord, this portion is the guiding factor of the writ petition, which can be considered by your lordship. Also, my lord, kindly in other annexure P18, the same prayer. He has prayed for cancellation of the deed. Perhaps this is not with the domain of the writ court, my lord. But this much only.
Yes. Yes.
My lord, I am for the respondent number 6, my lord. My lord, in the year 2008, my lord, in Alipur court, the respondent number 6 filed a title suit. There the suit is pending, and my lord,
suit is pending.
Pending, and there is an injunction on order 39. My lord. There is a recent order of the learned district judge, and specifically stated regarding the disputed plot. My lord, I will kindly hand over this.
Whether it is a part of AO?
Lordship?
Whether it is a part of AO?
No, yes, my lord. That is a part of AO, my lord.
Part of your AO? Refer me the number. Refer
My
the
lord,
page number.
when it was filed, my lord, AO, I was not admitted
Then
at
you have
that
to serve
time.
a copy to them.
I will serve, my lord. My lord, kindly for me just that I am. The petitioner, my lord, is disputing the plot, my lord, 12 and 12A, my lord. That is clearly stated by learned judge that
Yes. What is your submission now? In respect of the writ petition?
And in my lord, in respect of the petition, my lord, now, my lord, I am in disposition of that physical. I am not in physical position, my lord. I am suffering from chest blood problem, my lord, and
So that is the other way.
that and
What is the merit of the writ petition? Your submission regarding merit.
Merit, my lord, there's I do not find that my petition
Hard.
is.
Yes. Reply.
I have sent my junior to bring a brief. My lord, a Supreme Court has decided whether any persons makes a false statement and misguide the court, that she should not get any justice from his application should be dismissed. That is reported on 2003 volume 9 SCC page 401. Vijay Soel versus State of Punjab. That was also considered further and upheld 2008 volume 12. Yes, one book 2008 volume 12 page SCC 481 at page 497. K.D. Sharma versus Steel Authority of India Limited. Page কোনটা খুঁজছি K.D. Sharma না paragraph 51. Paragraph 51 কি লিখো? Page 497.
Give me the book.
Paragraph 51. এটা পেজ লিখিনি কেন?
Yes.
Lord, the judgment, my Lord, passed in the Vijay Goyal that has been reiterated in this act. Vijay Goyal, I have this judgment has been reiterated in this act. Paragraph has been, my Lord, noted in the case of K.D. Sharma.
Yes.
This judgment has been cited in the K.D. Sharma case, 2008.
Very hard.
From the documents I have tried to show your lordship, satisfy your lordship, that Milan Datta was not deciding at Lord 11H in Bhosle. He was deciding at C10 Digambo, C10, and it is also certain by the notice of the RR department issued by to C10. That's what it is. C10 Purbo Diganto, page 55. So he has made false statement that he has been deciding at 11H in Ghosh Lane.
Very hard.
And in the affidavit in opposition,
No fact, no further fact on reply.
that's right. Because when I am on the basis of the judgment, he made false statement.
I understand.
Thereafter,
I have heard.
yes, my lord, my lord, Milan Datta was, my lord, bachelor. It is stated by in the affidavit in opposition. The affidavit in opposition, it has been stated that Milan Datta was bachelor.
I have
But
heard
by
it.
the order of the, well, that, well, I recall.
Not necessary to further retaliate.
No.
Okay, okay. Heard.
I'm
Please
grateful to
take
your
down.
lordship for giving me a patient hearing.
Okay. Thank you. This is one of the writ petitions pending since long. Full stop. Learned counsel appearing on behalf of the petitioner submits that the petitioner was all along in possession over the settlement plot number 11 of the Chandpur Squatter Colony, SQATTER, colony number 1, Narendra Nath Ghosh Lane, Kolkata 700040. Full stop. His possession over the land was ascertained by several letters of the member of the West Bengal Legislative Assembly, as well as by the several documents
Lordship, I'll
of
be
the
allowed
employer.
to go, my lord.
Yes. Employer of the petitioner. He made a detailed representation with the authority in the year on 9th of February 2007, but the authority concerned has not acted over his representation. Accordingly, he approached this court. Vide writ petition number 4428 W of 2007. Coordinate bench of this court, one of the coordinate bench of this court, Vide order dated 1st of August 2007, has directed the concerned authority to dispose of the representation of the petitioner after giving sufficient opportunity of being heard to the petitioner and all concerned. In terms of such direction, the concerned authority has passed a written order on 21st of October 2008, being agreed by and dissatisfied with the said written order, the instant writ petition was preferred. Full stop. On perusing the prayer of the writ petition, it was surprised to note that the writ petitioner had challenged a deed of gift dated 21st September 2009, 21st September 1990 in favor of respondent number 5. Full stop. The deed of gift never placed before this court. Rather, the deed of gift was also not placed before the coordinate bench when the matter was earlier placed. It further appears that the deed of gift was not placed before the concerned authority at the time of passing the impugn order. I make it clear that if the petitioner is aggrieved of a deed of gift which was registered by the concerned authority, he may approach the appropriate forum to challenge the deed of gift according to the provisions of law. Next, in considering the impugn order passed by the respondent authority, it appears to me that the respondent authority is of clear view that the father of the petitioner, namely Manoranjan Kaur, within bracket now deceased, was in possession, was occupier of settlement plot number 12, And it was also noted that settlement plot number 12 and 12 capital A are joint plot. Full stop. The authority is of also view that settlement plot number 11, settlement plot number 11 was given under a freehold title deed in favor of Sri Milan Kumar Datto, within bracket respondent number 5. Full stop. The authority concerned has disposed of the representation directing the petitioner to approach the authority to prove the heirship, prove his heirship, H-E-I-R, heirship after demise of his father, Sri Manoranjan Kaur, now deceased. However, it is unknown whether the present petitioner has approached the authority or not. In so far as the writ petition is concerned, it appears to me that the written order passed by the authority after giving appropriate opportunity of being heard to the petitioners, and the authority has passed the written order on the basis of the documents and evidences on record. On plain perusal of the impugned order, I find no infirmity or any illegality in the order, written order itself. Moreover, the written order is not at all perverse or unreasonable. Thus, I find no justification to interfere with the written order. Full stop. Next paragraph. It appears that the writ petitioner has challenged the deed of gift which is a subject matter of a title suit pending before the learned competent court of Alipur. Full stop. The petitioner, this court refrains itself for passing any order in respect of the deed of gift. Full stop. Learned counsel for the petitioner, next paragraph, has also approached this court, citing the affidavit in opposition filed by the private respondent, wherein, according to the petitioner, the respondent have made a false affidavit. Full stop. Learned counsel for the petitioner has realized a decision of Honorable Apex Court passed in Bijoy Sayal, Vijoy versus State of Punjab, reported in 2003 9 SCC 401, wherein the Honorable Apex Court has held that in order to sustain within inverted comma, paragraph 51, wherein the Honorable Supreme Court in paragraph 24 has held that set out for which in perusing the observation of Honorable Supreme Court in Vijay Sayal, it appears to me that recruitment process was in question before the Honorable Apex Court, wherein the petitioner has falsely disclosed before the Honorable Apex Court that he had scored a huge marks, wherein the documents are stated otherwise. On that, the Honorable Apex Court has observed the finding. in this case, in this case, if according to the if according to the petitioner, the respondent has made a false statement, it is open to the petitioner to challenge the affidavit made by the respondent before the appropriate forum of law. However, the petitioner also not made any application for making for initiation of any criminal contempt against the respondent who made the false affidavit. Concerning the same, this issue be kept open to be decided by the competent authority if it at all raised. Full stop. Next paragraph. Under the above observation, I find nothing to entertain the present petition. According the instant date petition is disposed of as devoid of merit.
Lordship, one thing to be noted, Lordship, about the deed, the order before the Honorable Justice Dipankar Datta, the deed cannot be mentioned, Lordship. After passing of the impugn order by the authority concerned, the petitioner came to know about the deed, Lordship. Prior to that, that was not in the knowledge of the petitioner.
You can challenge it.
Yes, but in the writ petition before the Honorable Justice Dipankar Datta, that cannot be mentioned about the deed. The petitioner have no
Whether
knowledge at that point of time.
You have come to know about the deed of gift.
Yes.
You can challenge it.
Yes.
You can challenge it according to the law.
But that was
It
in
is
the
not
order.
the subject matter of the writ petition.
My lord, I am very sorry to mention, today, Monday, I am coming from Midnapur. So my matter was 1-4. I could not appear due to 10 late, my lord. Your lordship asked to go out of list. Can it be remain in the list subject, your lordship?
Come on Wednesday. You mention it on Wednesday by anyone. I place the matter.
Place the matter. I attended, but Monday I coming from Midnapur. Due to 10 late, I could not appear before lordship at the time. Let it be remain in the list. And also, as per your lordship earlier direction, application for
Have you filed the application?
that already been filed. That is in the list also.
That is in the list?
Yes.
Where is the application?
Can do.
Very well.
Can do.
এই অর্ডারটা কেটে দেবেন তো 14টা অর্ডার করেছেন গো টু দ্য লিস্ট এটা কেটে দিতে বলবেন ঠিক আছে এটা থাক লিস্ট
tomorrow
appear in the list. Okay, next.
My lord, item 19 and 20 may be taken up together, my lord. Two analogous revisions arising out of two analogous appeals, my lord. We were convicted under 138. My lord, on instructions, I'm not pressing both the applications, my lord.
Next. Both the CRRs.
Both the CRs, my lord.
You are appearing on behalf of the petitioner.
On behalf of the petitioners. Protima Bagchi, my lord.
Advocate on record.
My lord, I am not the advocate on record. The advocate on record is it's a solicitor brief, my lord. I'm led by Mr. Amartya Ghosh. My lord, the advocate on record is Mr. Prosun Ghosh.
So what is your submission?
My lord, on instructions, we are not pressing with both the applications, my lord.
Okay, please take down. What is your name?
My lord, I am Mr. Shorjudip Ghosh. I'm led by Mr. Amartya Ghosh, my lord.
Give me the names.
My lord.
Learned counsel. না নামগুলো লিখো লিখবে learned counsel appearing on behalf of the petitioner submits on instruction that the petitioner doesn't want to proceed further with this matter. Considering the submission of the learned counsel for the petitioner on instruction, the instant CRR being CRR number, দুটো নাম্বার আলাদা করে দেবে, দুটো আলাদা অর্ডার হবে। Is hereby disposed of as not pressed.
Grateful, madam.
Interim order, if any, passed by this court during the pendency of the instant CRR is hereby vacated. Next.
I appear. My lord, my client is one Mamta Bera who has been served with an application for appropriate orders. But she is not yet a party in the proceeding. Therefore, my lord, I am seeking direction to file affidavit in this matter because no interim order can be passed in this, and the appeal is waiting for more than 20 years. So,
my lord, suit for eviction decreed. I am the plaintiff landlord.
my lord, perhaps suit for
So
eviction.
can 3 is for impleading.
Correct. I'll tell your
impleading
lordship, just if your lordship gives me 1 minute. Suit, original suit, I am the landlord. I file a suit against a gentleman by the name of HON'BLE Meter. The suit, during the pendency of the suit, HON'BLE Meter, the sole defendant died. My lord, his class 2 heir was impleaded in the suit. Thereafter, it transpired that the sole defendant died leaving behind a will. So, my lord, the executor was also impleaded in the suit. Suit was decreed. Against the decree, the defendant number 2, which was the executor to the last will of the sole defendant, filed an appeal, first appeal. The first appeal was allowed. Now, my lord, the first appeal was allowed, may not be relevant at this stage in the substitution application. I'm not troubling your lordship with that. Was based on a coordinate bench, division bench judgment of this honorable court on a particular issue in respect of the same property. I'm allowed against the reversal of the decree by the first appellate court. We were aggrieved, so we are in second appeal. So, my lord, correct. We are in second appeal. Now, my lord, during the pendency of the second appeal, now it transpired that even the executor has passed away, and it further transpired, we came to learn that the probate proceeding initiated by the executor has been granted, and Mamta Bera, on whose behalf my learned friend appears, she is the auntie or the beneficiaries under the will. So that is why the present application has been taken out. This is one aspect. Now, the other aspect is that the substantial question of law which was framed was based on the division bench judgment of the Calcutta High Court, on the basis of which the appeal was allowed. That has been set aside by the Supreme Court. So nothing further remains. Anyway, that is on merits of the. So this application, since my learned friend is appearing, your lordship can. Nobody else remains against whom I
We
can
require to
proceed.
file an affidavit to this application.
Against can 3.
Against
that is a
this can-
substitution application. I want to
This
impede
is
them.
not a substitution application
All right.
simpliciter.
All right.
If your lordship goes by the cost title, it's an application seeking appropriate orders. Now,
if your lordship will see the prayers, I think
no,
that will be
yeah,
sufficient.
even if the prayers are seen, it does not pray for substitution of the legal heirs of the original defendant. Now, my lord, there's a lordship knows difference between Order 1, Rule 10, addition of a necessary and proper party, and Order 22, Rule 3.4, where substitution is sought for. Now, each substitution is coupled with abatement, setting aside abatement, if abatement has taken place, read with Limitation Act. Now, my lord, what my learned friend is trying to do is to substitute the original defendant, because the executor was a stopgap, interim substituted person in place of the deceased. So now the successor, predecessor in interest is being substituted by the successor in interest. So it has to be a substitution. Now, if substitution comes in, there is abatement. No prayer is there for setting aside abatement. Abatement has taken long back, 5 years back. Now, my lord, I wish to file an affidavit to this because this application per se is not maintainable.
Very. You can.
My lord, may I just indicate this, my lord?
I know he has the
No,
opportunity.
my lord,
to file.
because this argument I'll show you, lordship, my lord, what my learned friend is trying to, my lord, he wants to file an affidavit for what? I am saying, my lord, there is no question of death. At the suit, the executor was impleted.
Yes.
So executor is an office. He was representing the estate of the deceased. So now that will has on the estate which he was representing.
I shall hear it out on the day.
So
when
these
the
are all factual aspects which are to be
Well,
recorded.
your lordship can understand.
The executor
My
expired
decree is
5
of
years back.
2003.
Yes.
Only 20 years have passed. They are sitting on the property. So your lordship can understand. The more the hearing takes place, the better it is for them.
Yes, and prosecution was in their hand. They waited merrily for 20 years.
No.
Now
that is not
suddenly
how-
they find
Where
speed in
is
the
the
matter.
prosecution was in my hand?
Yes,
I
second
obtained the
appeal.
decree, then first appeal, then second appeal.
Second appeal.
Counsel
Second appeal is
wants
of
to
20.
use the affidavit. I can allow him.
Lordship.
Okay. The
Short direction.
please take down. Mr. Mal, Mr. Sanjeev Kumar Mal, learned counsel appearing on behalf of the proposed respondent.
Lordship will mention from
Mamta Bera.
Mamta Bera.
Mamta
Mamta Bera proposed
Respondent.
Respondent.
Proposed respondent. কি বললাম? Mr. Sanjeev Kumar Mal, learned counsel appearing on behalf of
Not
one
Mamta.
Mamta Bera within bracket proposed respondent intends to use affidavit against scan 3 of 2025. Let the affidavit be filed within a week.
My lord, at least 2 weeks, my lord. At least 2 weeks.
2 weeks you want? Okay. Let the affidavit be filed within 2 weeks. Let the matter appear in the list on 25,
Grateful, my lord.
25th of March.
Grateful.
My lord, today is 18th, my lord.
Today 18th?
Oh,
17th. Okay.
It will be in April first week.
Very well, very. 2nd of April. 2nd of April. Under the same heading.
2nd of April. Very well. My lord, may the affidavit of service be kept on record.
Affidavit of service filed on behalf of the petitioner be kept on record.
Grateful. এই আমার নোটটা ঢোকাবে কে আছে
Initially, when I was engaged, I just inquired from my junior friend. আরে ভাই তুমি যে মাই লর্ডের জাজমেন্টটা দিয়েছো ওটা কি আদৌ অ্যাপ্লাই করে এখানে? Now he thought, he said, to some extent correct. Subsequently, he bought a judgment of your lordship, which is very on same point. They get large judgment because I'm making the same prayer to shorten your lordship's valuable time. Under similar circumstances, I'm praying. Is the checkered career. Mr. Sarai, he is actually an expert of the subject, and whenever we are appearing, I found he is there. Last part of order, they can proceed, but no effect be given. So, my lord, my lord certainly can ask me these questions. Mr. Raji, why you are so scared to move earlier? I say, because the basic difference between two, the judgment order which is annexed in the petition, with the petitions, my lord, actually there, my lord, he wasn't track, he was doing business. But here, prospective. Here, my lord, kindly see paragraph 2 of this order, last word.
Yes.
There, the same thing. Second paragraph. So the core issue is which will prevail over whom, whether that is still in existence or not. My Lord Justice Patnaik, my Lord, and in the judgment decided some issue, which is to be tested by the Honorable Division Bench. My Lord passed an order, only naturally, my Lord, that well, otherwise there were precarious conditions, judicial system to be followed, and my Lord dealt with everything. That order also challenged. My Lord Justice Jayamalla Bhakti, sitting in the division bench, said, no, nothing wrong in his order. Order is good. Order will continue. So what I am on at the present moment, kindly pass a similar order so that for the timing there shouldn't be any confusions.
Okay. Yes.
There is a basic difference of two orders. Your Lordship modified one order. There is a doubt. Kindly turn to page 10. This is the order passed by Justice Joshua Gupta in the petition filed by learned senior. Page 10.
Page 10. Page 10 of the writ petition.
It's application. 10 number 2. Cancel. Application for appeal. Page 10. The order passed by Justice Joshua Gupta on 1st February 2023.
Yes.
Page 10. In view of the point taken up by the petitioner that in the Central Controller 2015, there is no provision for a distributorship. Let the respondent not finally appoint any candidate in respect of the vacancy notification in question. However, there shall be an entitled otherwise possible. This is an order until further order. This order still exists.
Yes.
We filed application.
Why?
That has been allowed down. Then, my lord, kindly turn to what has been modified by your lordship. Kindly turn to page 54. What are that requirement? Page 54, kindly turn. This is passed in another proceedings.
Yes.
Well, kindly turn page 54, last 3 lines. On the same issue is submitted by the learned advocate for the petitioner and appeal is pending before the division. Kindly take note. Over the Honorable Chief Justice High Court.
Page 55 you are reading?
Page 54, last 3 lines.
Okay.
Sentence starts on the same issue.
Yes.
On the same issue, which is submitted by the learned advocate for the petitioner, an appeal is pending before the division bench, presided over by the Honorable Chief Justice High Court, Calcutta. The instant petition is admitted for hearing in order to avoid conflicting decisions by this court and the division bench of this court. Vacancy notification dated so and so extend till the disposal of the mandam. So, at the moment that appeal has been disposed of, this interim order goes. So far my learned student client is concerned, so far this interim order is concerned, that is unlimited. This interim order has gone due to order passed by the division bench. Now, what that is in, we file an application. In that matter, take 56, your lordship modified the order, and which has been appealed. So, my lord, so far my learned senior client is concerned, interim order is still there. That is not till disposal of the appeal. We are not taking any steps. We cannot. We are added as party respondent.
What is the prayer in the application? Prayer in the application in terms of MAT 1543 of 2020. Yes. This is the only prayer.
Yes. But they are enjoying an interim order. Page 10, already there is an interim order till disposal of the writ petition.
Now, disposal of the writ petition of that writ petition.
Yes, that writ petition. This writ petition. This writ petition. Kindly come to page 10. This is the order passed in the instant writ petition.
Okay.
This is passed in the present writ petition. None can touch my learned senior friend's client.
The Miraj Act principle. You are touching me, that's a problem.
Cannot.
Why?
Why
Let me record it.
Modification is necessary because this is until disposal of the writ petition.
Sorry to interrupt, my lord. I think this judgment, this order, he appeared. I don't know whether it is within his knowledge now or not. I just help him. Just have a look, my dear friend.
I'm out with this. You have annexed it.
No. That is subsequent order. My dear friend, you are there. The similar case, similar circumstances.
You have annexed also same order.
No, no, no,
Yes,
no,
yes,
no,
kindly
no.
come to page 54. Kindly come to page 54, the same order.
No, my dear friend.
Yes, yes.
No, no, no. It is not same order. Fellow করবো কেন?
But you have to kindly consider.
এইটা
No,
করে
no.
দেখ, করে দেখ।
Let us
এটা
go
same
to
order
it.
নয়।
Let it appear on the next day.
Intending eligible candidates
Ah.
appeared before this court
Yes.
to pray for a relief. The relief was granted by this court till the disposal of the MH
Yes.
15 to create division
Not
bench.
to finally appoint. Much better order. Now your lordship is passing not to dealing. Division bench has passed not to dealing that
Not to
order.
dealing.
So for my learned friend client is saying he's more protected.
Oh,
Not to fight- not
I'm
to
really
fight.
very happy to see
Yes, yes, that's the
one
order.
one thing.
That's the order. Kindly
One,
come to page
one thing. I expected the argument which will come from my friend, who's very experienced expert in this line, my lord, that well, this petition cannot be entertained for review assistance because the status of the petition is quite completely different. That's why I started with this, my lord. I'm a little bit hesitant. By tomorrow, when I got this order, I go, Nari, the same point that was dealt with by your lordship, and we are similarly placed. So really, that is
No, no, that is not the argument.
Yes.
I understand.
no. He didn't argue. I expected that argument to start.
Not, because there are cases.
No, what is your prayer here?
There, my lord, kindly protect me, so that there should not be.
It is the submission. You are already protected.
Kindly record it, my lord. I don't mind.
That protection
Yes.
is always there.
What is the submission?
That protection is
No, no, no. Why you hesitate? Kindly, kindly record it, my lord.
What is the status of the matter? What is the status of the
Ah.
vacancy?
Department cannot proceed with the matter.
Yes.
No, no. Let him say. Let him say.
Today is the feast for hearing of the application. You must have aware about the matter.
And you have served the copy earlier.
Same page.
No, my lord, I don't know why he is emphasizing much. If you and he's avoiding to give any undertaking. No, he will not proceed. He will not do anything. I am very much scared. I'm at the cost of reputations. Again, I will say, my lord, original petitions, there is some problem. I expected that argument will come from him. Judgment, no. Subsequently, and he is not aware of this judgment, though he is appearing. Yes. So now, when I showed you losses, my lord, problem is gone. Here is a perspective, my lord. That's very vital. My lord also protected to avoid all future complications. Because every day cases are coming because of the fault of the part of the authority. So in order to cover all this is, my lord,
Independent interim order without relying on division bench judgment.
বুঝলাম তাতে হলোটা কি?
In that case, division order has been passed till disposal of the appeal. Appeal has been dismissed. So requirement was there to modify the order. Kindly see page 10.
No, my lord, kindly
Last
see.
paragraph.
If that is so, my lord, I don't know what the effect of impact of that, of the single bench order. Kindly protect us, my
You
lord.
have the point taken up by the petitioner. This is the independent order.
Why so side to
In the
give an
same
undertaking?
There is no provision for distributor. Let the respondent not finally appoint any candidate if in respect of the vacancy in question. However, they shall be entitled to otherwise possible. This is fully protected.
Okay,
There
that's
is no
all.
meaning of any division bench judgment.
No, well, I can understand. State is taking stand.
No. I am
It
the
is a
person
state.
concerned. I have
No,
been approved.
That is all thing.
Yes.
He is being
Yes.
approved. That's why he's taking this stand.
Well,
But that is not one of the business.
Which order your lordship has
Question
been
is this,
modified?
my lord. How you are affected? If any other
Of the further order.
how you are no, why you are what is your problem? How is
Problem
affected?
is that, my lord, this order cannot be modified. Kindly tell me page 54. Which order your lordship has been modified? In that order, your
I
lordship
can
has the order.
understand. Sorry to interrupt, my lord. I can
order.
understand state is coming
That is
and
not
taking the
there.
stand.
Why should I?
And my lord, he is saying, I undertake, nothing is done.
No, the issue is that I have to hear about the state regarding the status of the vacancy. Tomorrow?
I don't mind. I don't mind. I am ready. I am ever ready, my lord. Already put the switch, my lord. I'll come.
Okay, you take instruction.
Nothing has been happened, I am saying. because
Okay.
I have
Please
given
take up.
approval. No further steps cannot be taken.
Let me hear the state. Can 2 of 2025. Learned Mr. Amritalal Chatterjee, learned counsel appearing on behalf of the state sought for seek accommodation
more protected.
for
I'm seriously telling
proper
you.
instruction. Let the matter be adjourned today. This the matter tomorrow
তুই তো মাস্টার
for further head for further consideration. Tomorrow.
tomorrow very well my lord
Tomorrow another same heading.
For your information, I'm sitting there. Not to dealing হয়ে গেলে মানে লাইসেন্স দেওয়া রাইট চলে আসবে। I'm get to.
এটা কি
Next,
ও এভিডেন্ট অফ সার্ভিস নেবি ক্যাপ্টেন দ্যাট got my
affidavit of service filed on behalf of petitioner taken on record.
mainly mother
I'm get to.
Kindly, my lord, make it not today because my senior is engaged in another court.
These matters, Lord, suppose we
What is
filed
the
one,
matter? What is the application?
my lord, we filed one affidavit regarding these matters, my lord, that was affirmed prior to the substitution, my lord. And at present, that was substituted and the son of the petitioner substituted as the present petitioners. For this regards, my lord, we want to change the affidavit. If my lord did as we file this affidavit, but it is the name of the prior petitioners, my lord. That was substituted in the name of the son or substituted in the instance of the petitioners, my lord. That will be it will be required for the affidavit to
What
be
is the
affirmed.
can do for
Can mean
appropriate order?
appropriate orders.
Appropriate order, what order?
Because one notification has been initiated by now, the restraining for the notification, they're not to give any further effect of the notifications. Because it's the compensate appointment that and that was one of the in the time of 1980s, my lord, the license was suspended due to some criminal proceedings and he was acquitted, and the challenging these orders, lordship, there's some findings of deputy secretaries that they withdrawn the security deposit. For this reason, there is no status of the petitioners and fresh vacancy was initiated. And challenging these orders, my lord, a writ petition was filed. And in the meantime, my lord,
They
petitioner.
are saying that they had not withdraw the security
Lordship,
deposit.
that is the main questions.
That is the main question. So,
questions.
you have used the affidavit.
Yes, we already affidavit was affirmed at the point of time that the petitioners was in. After that, the petitioners died and son was implemented as substituted in his place, my lord. We already affirmed this affidavit in the prior, my lord.
Now, what about the fact regarding the withdrawal of the security deposit? Have you stated about
We are
name in the affidavit?
that was stated that at the point
It
of
was
time
dealt
one
with?
not that
No.
that was dealt with, my lord.
Dealt with.
Dealt with.
Already dealt with.
Dealt with.
So what is remain? The hearing can be done.
If my lord desires also, I will file this affidavit.
Why?
If my lord directs, then I will file affidavit.
No, already direction is there. State authority directed to submit a report in the meantime.
Because in the meantime, the substitution is there, my lord. The son was substituted in the place of the petitioners, Jitendranath Das. The main license is Jitendranath Das. And
Jitendranath Das was the license. He expired.
He expired. His son substituted in the place
son
of
was substituted.
substituted.
So what happened? You have used the affidavit.
Yes, my lord. This kindly says.
What is this? Report.
Report, man.
You have stated the name Jitendranath Das. That's why you want to.
Yes,
that is
the
you
problem.
place it. You serve a copy.
If my lord directs, then I.
Okay.
I'm handing over this copy, man.
In terms of the direction of this court dated December 10th, 2024, the state respondent submitted a report in the form of affidavit. Full stop. Let the affidavit be taken on record. Mr. Amrutala Chatterjee, learned counsel appearing on behalf of the state, fairly submits that the name of the petitioner was erroneously stated in the report as Jitendranath Das, though the said Jitendranath Das, within bracket erstwhile licensee, has already been expired and in his place his son was substituted in this proceeding. However, considering the entire matter, the report in the form of affidavit filed by the state respondent is accepted.
Grateful, my lord.
Full stop. The matter is otherwise ready for hearing. Let the matter be placed on hearing. on,
My lord, there's a chance to give the exceptions of this perhaps, my lord. They should
Okay.
given a chance to exception.
okay, কি বললাম বলো? না, ওটা কাট। The matter is otherwise ready for hearing, কেটে দাও।
In the meantime, there's
Okay. The matter be placed under the heading of hearing on 2nd of April 2025. The petitioner may use reply
grateful, my lord.
against the report by the state in the meantime.
Grateful, my lord.
Deeply obliged, my lord.
Next.
I am for the statement. Led by
My lord, hearing on behalf of the petitioner in this matter, I'm sorry, my lord, I could not present before your lordship due to my health reasons. Am I audible to your lordship?
Yes.
My lord, due to my health reason, I could not be present before your lordship. I'm sorry for that. That's why I'm submitting online, my lord. Kindly take it up tomorrow or day after tomorrow, my lord. I will be hearing this matter physically before the lordship because it needs required submission. So,
Very
my
well.
lord, 2 days time.
Day after tomorrow.
Day after tomorrow.
Great.
Yeah, I'm grateful.
Yes.
I'm for the petition. I'll take it not today, make it not today. But I have a difficulty to in the second half. That's why I'm paying.
Difficulty?
In second half, I have to.
Very well. 25, not today.
Great.
Not today, 25. দেখি শোন। Second half এ কি আছে? এতগুলো কেন? এতগুলো ফিক্স ম্যাটার হয়ে আগে থেকে ফিক্স হয়ে আছে।
সেকেন্ড হাফে কি এটা কন্টিনিউ হবে? হ্যাঁ,
ঠিক আছে, দেখা
কিছুই
যাক।
বলতে পারছেন না আপনারা, কি করেন?
একটা দুটো করে রাখবেন, ঠিক আছে, আদারওয়াইজ এতগুলো কি করে শুনবো? ঠিক আছে।
মানে in the second half it will continue.
Yes.
টু বি মেনশন আর ধরবে?
Call the list.
Item number 3.
আমাদের
I'm appearing for the petitioner. The one difficulty I'm facing. If your losses kindly consider your lawsuits order dated 24th July 2024. 24th July 2024. Well, your lawsuits, the respondent number 4 was given liberty to file affidavit in opposition within a week from date, and then reply, my lord, by me within a week thereafter. Now, my lord, they have served on 7th March an affidavit affirmed on, my lord, January 2025. Just, my lord, few days before 16th day of January 25 affirmed, served on 7th March by letter dated 6th March. So, my lord, I wanting your losses, give me a week's time. In the meantime, I will give him an advance copy. It's out of time, but that's not the point. Your losses, they have used. Kindly accept their affidavit, but I have to take exception to that. This is on record, affidavit in opposition. Oh, Debi, down it. They have not yet filed. So, give me a week's time, I will come back before losses.
What is the matter? Why it is appearing under the heading order?
Because your losses probably, this is in regard to grant of dealership, ration dealership. Certain points were urged, and that's why probably your losses prompted to take it up as for orders.
Which for the respondent, private respondent?
My learned friend just now submitted this.
Yes. Have you used affidavit?
He has filed the report. I have
in the
taken
form of
I have taken exception to that also. So I have to take my reply, file my reply against this. My learned friend ought to have filed much before. Anyhow,
What are the issue involved in this matter?
my issue, my lord, that they didn't fulfill the criteria under the notification. And
Private respondent.
private response. His appointment has been, selection has been questioned.
There you. Affidavit in opposition filed on behalf of the respondent number 4 be taken on record. Petitioner at leave to file a reply against the affidavit within 1 week.
Yes.
Let the matter appear in the list on 2nd of April.
Under
the heading to be mentioned.
For orders, your losses keep it. So that to be mentioned, your losses normally for any clarification or that. As well as it appears today.
Okay, under the same heading.
Or at 2 p.m. your losses.
No, not 2 p.m.
Then your losses at the top of the list.
Under the same heading for orders, it will appear after motion.
After but then that will delay your losses. Kindly do not give me the opportunity. Hearing for orders hearing shop time. Even I can hear before my lord argue as to be mentioned. Name kichu jay ashe na my lord.
Yes. It will be better to fixed on to be mentioned.
And do that, your losses. Do that.
To be mentioned.
Let us understood that we will argue on the hearing. Good. Second. এটা কি নাম নুরুল ইসলাম ঠিক আছে এটা মানুষকে দিলাম আমি সাজিয়ে দিচ্ছি
Next.
Respondent oil company.
So on the last occasion, your lordship remembers that I was distinguishing the judgments, and all the judgments which has been produced are on the recruitment process in a organization from the impanel list of candidates, which says that this does not create any right for appointment. My case is of a tender, not a recruitment process, not guided by any law or by any rules.
Yes.
Guided by equity, fairness, and your lordship, the principles of promissory estoppel and reasonable expectation. But there is only one selected candidate. There are no impanel list of candidates from which a person has to be declared as a successful tenderer. Your lordship will Your lordship will see from the list I have distinguished till item number 6, your lordship has this list of judgments which till item number 6 I've distinguished. So the next judgment,
Yes.
the judgment, your lordship, if your lordship sees the list, serial number 7, 2022, volume 12, SCC 120. This is your lordship.
Yes.
Will kindly come to the judgment. It's on the point that if a court passes an order beyond the purview on which the matter was remanded back to the court's order, then such order is beyond the jurisdiction of the purview and the order is bad. Your lordship, for this, your lordship, I don't know why this judgment has been cited, maybe on the ground, because your lordship remembers that my writ petition was initially dismissed, because the honorable single bench was of the opinion that since somebody else has already, his distributorship has been restored, nothing remains. Lordship will take my supplementary affidavit, and thereafter I went to the division bench. The division bench remanded back the matter to the honorable single bench, keeping all issues open. Lordship will kindly see the supplementary affidavit which I have filed. May I just first place the single bench order which was passed in my writ petition after the distributorship of Bimola Gas Service was restored. Page 22. The court sees absolutely no urgency in the matter. The court was misled into listing the matter. The lordship is searching the supplementary affidavit.
Yes.
The supplementary affidavit আছে একটু দিন না জজ। যখন অ্যাফার্ম করেছি 11 জানুয়ারি 2024 এ।
সাপ্লিমেন্টারি এটা দিন।
11 জানুয়ারি 2024 এটা কোন বাইশ একটা এখানে প্যারা 10
It can. Supplementary affidavit by
the petitioner affirmed on 11 January 2024.
Yes.
Lordship will take page 22 first. The Lordship has got it. Second, 6 December 2019. The court sees absolutely no urgency in the matter. The court was misled into listing the matter on the basis of reference to an order rejecting SLP passed by the Honorable Supreme Court in another writ petition. The court is of the view that since the order of cancellation of dealership in respect of the place where the writ petitioner claims that he has been allotted the dealership has been set aside in the writ petition and confirmed by the division bench and by the judgment of March 27, 2019, the same has been confirmed by the Honorable Supreme Court. The instant writ petition has become infructuous. Consequently, the connected application has become infructuous. Copy of this is taken on record. Now, from this order, we preferred an appeal. That is at page 24.
Yes.
23rd December 2019.
Division bench said all issues kept open.
Yes, all issues kept open.
All issues kept open. Remanded the matter back.
Correct. Now, it is my learned friend's contention, I believe, on behalf of the private respondent, Bimola Gas Service, that the matter has been remanded back for a limited purpose. All these issues which I have raised cannot be looked into. I don't know why this submission has been made, because he could not explain his submission. the point which he was trying to make, he could not explain that why the single judge, after the matter being remanded back, should not consider the writ petition on all issues raised. That, in my humble submission, he could not make it clear. So on this proposition, the judgment of 2022, volume 12 SCC was cited. This judgment of 2022 is on the ground that if a matter has been remanded back for a limited purpose, court cannot go beyond that. The learned single judge. But here the matter, division bench order does not restrict your lordship to decide a particular issue raised in the writ petition. That the court will only look into those issues raised and will not consider or look into other issues which the writ petition is ventilating in the writ petition. It's a simple order of remand. If the matter is simply remanded back, the honorable single judge is left open to decide all issues. So there cannot be any restrictive consideration of the writ petition, because the division bench does not put any embargo upon the single bench, compartmentalizing the issues which the single bench should decide and compartmentalizing the issues which the single bench should not decide. That is not there in the division bench order. So your lordship is free to decide all issues raised in the writ petition.
Division bench order, page 24.
Division bench order, page 24.
All issue was not kept open.
Your lordship will see. It's a simple order of remand.
Simple order of remand.
Correct. So simple order of remand means that all issues are kept open. Kindly see the order. I will just place the order from the last paragraph of page 24. At an earlier point of time, the dealership of one Bimola gas service has been terminated by the Indian Oil.
Last paragraph, page 25.
Yes. In those, we set aside the impugned order dated 6 December, remand the writ petition to the learned single judge for consideration.
Yes.
So the single bench order, on the ground that my writ petition has become infructuous due to restoration of dealership, has been set aside in toto, in limine. So the entire order has been set aside.
Yes.
It is replaced by the honorable division bench order saying that no, since Bimola gas service has not been made a party, there was a flaw in passing the order, because without hearing Bimola gas service, the writ petition could not have been adjudicated to its logical conclusion. Whether rights of Bimola gas service has already accrued or not, whether due to restoration of dealership of Bimola gas service, my right is affected or not, whether I am entitled to claim my right to be appointed as a dealer in spite of restoration of dealership of Bimola gas service or not. So on all those issues, the matter has been remanded back. Simplicity remand. So lordship is free to decide all the issues. The division bench has not restricted your lordship to decide a particular issue in the writ petition. So this judgment, in my humble submission, is actually completely different and not applicable in my case.
Okay.
He has relied upon your lordship paragraph 10 and 11. Kindly take paragraph 10. It must be pointed out at this stage that in the first instance, the Executive Council took a stand that the selection of the appellant was vitiated primarily on account of non-inclusion of subject experts in the field of Karamkan. The appellant was not held by the Executive Council to be a person not possessing the prescribed qualification for appointment. This is why the order of remand passed by the Honorable Court on 2nd December 2011 specifically directed the Chancellor to consider whether or not there were subject experts in Karamkan to be included in the selection committee. So kindly see, here the matter was remanded back specifically to the learned single judge to decide a particular issue. It was the division bench has made it clear in its order that what issue the single bench should decide and on what consideration, for what decision the matter is remanded back to the honorable single judge. What is the issue to be considered? Then it says, instead of confining himself to the said question, Chancellor seems to have taken the opinion of Professor Gayaram Pandey, head of Department of Sanskrit, to come to the conclusion that Karamkan and Sanskrit are two separate subjects, and that is why Karamkan is a practical subject, Sanskrit is not. So the issue was different on which it was remanded back. But it decided, the single judge decided something else. So that's why in paragraph 11 it says, obviously the consultation made by the chancellor with certain persons and information gathered by him from the before passing the order imputed before the High Court were beyond the scope of the remand passed by the High Court. So that's why the order was found to be erroneous. But here there is no such restriction.
Yes.
Here there is no such issue which has been framed by the division bench for decision by the honorable single judge. So that's why this judgment is not applicable at all. Actually different. Then, Your Lordship, the next judgment, serial number 8, 2016, volume 6. SCC 532. This is also, Your Lordship, same similar judgment. This judgment also deals with the case of recruitment in a particular organization. It's not a tender matter.
Yes.
Here, Your Lordship, what has happened? There were certain candidates who were seeking their appointment in respect of certain vacancies created in a D-reserve post, which was initially reserved for the SC and ST category. Here, Your Lordship, the Honorable Single Judge writ petition was filed since the post was D-reserved and he was not given appointment in the reserve category. Writ petition filed, the High Court said that in Article 226, allowed filing up of vacancies by de-reserving the posts where reserve posts were kept for scheduled caste and scheduled tribe by general category candidates. In this case, there was, Your Lordship will see, there was a legal bar under Section 7 of the Punjab SC and SC/ST Act for de-reserving a reserve post. In violation of that, the de-reserve posts were reserved by the government. So since there was a violation of law in de-reserving the reserve post, the court held that the selection of the candidates does not give any right of appointment. My Lordship will straight away take paragraph 2 facts. Brief facts which led to filing of these appeals are as follows. The Punjab Public Service Commission issued advertisement for filling up 52 posts of Punjab Civil Services. White advertisement dated such and such. Out of 52 posts, 27 posts were of general category, 25 of reserve category, which included 3 posts for ex-servicemen, 2 posts for physically handicapped, 10 posts for scheduled caste, 3 posts for scheduled caste ex-servicemen, 5 posts for backward classes, 1 post for backward class ex-servicemen, and 1 post for sports person. Then Your Lordship will kindly take the three lines thereafter on the same paragraph. 27 candidates from general category, 10 candidates from scheduled caste, and 5 candidates from backward classes were declared successful and have joined in terms of the letters of appointment issued to them. 8 posts were de-reserved in respect of the remaining unfilled vacant post. As against the said de-reserved post, 7 candidates from general category, that is candidates up to serial 34, and 1 candidate from backward classes were offered appointments. However, 3 candidates belonging to the general category, namely Sumit Gagak and such, place serial number 1, 5 and 32 respectively, did not join. Then Your Lordship will take paragraph 4. Feeling aggrieved, the appellants filed a writ petition before the High Court contending that 3 vacancies which remain unfilled due to non-joining of 3 candidates should have been offered to them as they were next in the order of merit. The High Court dismissed the writ petition, holding that the appellants have no right to be appointed against vacancies falling vacant due to non-joining of 3 candidates of general category. It was further held that as against 27 vacancies available for general category candidates, 31 general category candidates have already joined and are actually working. That is, the candidates much more than the vacancies advertised have been permitted to join, and thus the select list of 2007 is stand exhausted. Aggrieved thereof, the appellants have preferred appeal. Then Your Lordship, the finding at page 8, paragraph 8. As against 27 posts of general category advertisement, all 27 candidates joined. Out of De-reserved 8 posts, 1 post was filled by backward class candidate and remaining 7 posts were filled by general class candidates. 9. There is no denying that the appellants were placed in the selection list at serial number 35, 36 and 37. In the 16th meeting of administrative committee held on such and such, considering the representation of the appellants, it was resolved to recommend, subject to approval of the full court, to the government of Punjab for their appointment as civil judges subject to availability of vacancies. But in the 18th meeting of administrative committee held on 6 July 2011, the committee took note that the direction issued by the Supreme Court to appoint 22 candidates selected in the year such and such who were not earlier appointed due to Sidhu scam. To accommodate those 22 candidates, the government of Punjab had sanctioned 16 temporary posts will be abolished by one when a vacancy becomes available. Then your Lordship, paragraph 10. This is what he has relied upon. It is fairly well settled that merely because the name of the candidates finds place in the select list, it would not give him indefeasible right to get an appointment as well. The name of candidate may appear in the merit list but has no indefeasible right to be appointment. So does this principle apply in my case? It's in a case of a recruitment process in organization, guided by certain rules and regulations of the same organization. Under those facts and circumstances, this is the proposition of law which has been set down. Then, your Lordship, paragraph 13, paragraph 14. On behalf of the appellants, it was contended that one posts were de-reserved and appointments were made as against the said de-reserved post, and the reservation was not challenged. High Court urged into going into the question of de-reservation as noticed above. Out of 52 posts of Punjab Civil Service advertised, 8 posts of reserve category were not filled up by Public Service Commission. Filled up and Public Service Commission de-reserved the post. Then, next, on the same page, after the figure given, paragraph continuation of paragraph 14. Out of the said 8 reserved posts, 1 post was filled up by a backward class candidate, and the remaining 7 posts by a general category of candidates as observed by the High Court so far as
the recruitment process and everything is there.
everything, Your Worship, same. So far as since they have cited, it is my duty to distinguish. Otherwise,
okay.
Now, Lordship will see the next paragraph. There was no statute. However, in respect of de-reservation of 1 post of scheduled caste category, Section 7 of Punjab Scheduled Caste and Backward Classes Act 2006 prohibits de-reservation and stipulates the manner in which de-reservation could be done. Paragraph 15, by perusal of Section 7, it appears that as a general rule, there is a bar on de-reservation of the post reserved for scheduled caste candidates. However, subsection 2 provides an exception to the general rule by laying down that in public interest, the authorities may, by passing order in writing, de-reserve the post.
Yes.
So, Lordship, under those circumstances, in paragraph 16, it was held that why it could not create appointment. The learned counsel for the appellants contended that when the other candidates were appointed in the post against the reserve category, the same benefit should be extended to the appellants. Article 14 of the Constitution of India is not to perpetuate illegality, and it does not envisage negative equalities. Then, Your Lordship, after this paragraph of the judgment has been cited, next, merely because some persons have been granted benefit illegally or by mistake, it does not confer right upon the appellants to claim equality. So, since there was a bar under Section 7 of the Punjab of the State Act against de-reservation, that's why it held that the appointment procedure is entirely bad. Since one person has been given the benefit, that does not create an equity in favor of your person.
Yes.
So, under those circumstances, it was held that it will not create any right, title, interest, even though you are a selected candidate to get an appointment. This is factually completely different. My case is a case of tender. There are no other selected candidates in a panel from which selection can be made in a recruitment process. Now, next judgment, Your Lordship, is the judgment of 1997 10 SCC 264, in which my learned friend has relied upon paragraph 12 and 13. Here also, Your Lordship, the facts are similar. That selection was done was made
This
in
is also recruitment process.
in violation of law. So that's why, Your Lordship, under the Section 4 of UP State Universities Act, so court said that since appointment has been done in violation of law, that will not create any right, title, interest. Ultimately, appointment was not given. Your Lordship will just take page 265. In short, it has been mentioned, the operative portion. Held. In the instant case, the process of, Your Lordship, 265, next page. In the instant case, the process of selection to the post of readers involved only interview, which was started on 12 December 93. Thereby, in view of the explanation under section 15(1), the process of selection was initiated after the Act has come into force without applying the provisions of 3(1) of the Act. Therefore, the process of selection and preparation of merit list was in violation of the provisions of the Act. Then, Your Lordship, the next page, this is paragraph 11, this is what he has relied upon. The process of selection must be held in accordance with law existing as on the date of selection. Keeping a candidate in the waiting list does not confer any vested right in his favor, much less an indefeasible right. The appropriate appointing authority is not obliged to fill up vacancies or to appoint any candidates in waiting list on a resulted vacancy due to the operation of law. The Vice Chancellor therefore was obliged under the Act and vested with the duty of right to take action and for filling up the vacancies under section 3(1) for recruitment in accordance with law. Then, Your Lordship, paragraph 12, it has been mentioned next same page. The legislature is competent to make the law retrospective. The Act was applied to existing vacancies. There is no vested right to a vacancy in a post. The person has a right only to be considered according to the rules in force as on the date of consideration. Any selection process initiated after the commencement of the Act has to be in conformity with the provisions of the Act. A mandamus cannot be issued to violate the law or to act in violation of the law. In the instant case, direction was issued by the High Court tantamount to direction to appellant to appoint the respondent as per the order of Chancellor in violation of the Act. Therefore, the mandamus issued was clearly illegal. So here, Lordship, first of all, there is no rules and regulation or law which governs the selection of a person as a successful bidder. I have been selected to give an appointment under this selection process. There is no law or regulations guiding this.
You are not selected, LOI are given.
LOI has, no, I have been selected as a H1 bidder. Yes. Only the tender has not been allowed. I have been selected. There is no doubt as to that. Your Lordship, I will just clear out the doubt here and now. Selected is I was declared as the H1 bidder.
Draw of lots.
Yes, paragraph 19, page 19 of my read petition.
In draw of lots, you have been selected.
Correct. This is the process.
Yes.
Thereafter, pursuant to the selection, I have altered my position. I have arranged the godown. I have arranged the land. I have paid the money. I have performed all the requisite formalities. They have been satisfied with my position, with my documentation, with the subsequent steps that I have taken. And field verification was done after this declaration. After that, I have been found that LOI should be issued. Page 19, the language is that.
LOI is not issued.
No. That's why I came up in the petition. We are pleased that you have been declared as a successful candidate in the tender.
Yes.
So here, Your Lordship, since there was a violation of law, in violation of law, the appointment procedure was conducted. That's why the court said that in any way, since there is a violation of law, the entire appointment is bad. That will not create any equity in your favor. There is no violation of law here, which has been pointed out by my learned friend. So how this judgment is wholly not applicable. Then, Your Lordship, the next judgment is 2009 volume 7 SCC 388. This judgment has been shown. Paragraph 30. My learned friend has relied upon.
There is no arbitrariness on the part of the. That
No,
is the argument. There is the argument that there is no arbitrariness on the part of the
correct
oil company. So,
but when the single bench passed the order, that you show that if there is any legal restriction for appointing a two distributor, they could not show it. Their argument was that it depends upon the ceiling limit, the defilling limit. If it goes above 12,000, then second distributor can be appointed. There is no rules and regulation which restricts IOCL from appointing a second distributor. And I showed from the Sensex document and the document issued by the municipality that there are more than 14,000 households in the municipality area of Dhupguri. So if each household requires at least one cylinder in a month, then it goes above 12,000. So as per their own contention, then there cannot be any bar. Paragraph 30 of the 2009-10 judgment which is relied upon. Interim order is passed on the basis of prima facie findings which are tentative. Such order is passed as a temporary arrangement to preserve the status quo till the matter is decided finally, to ensure that the matter does not become either infructuous or a fait accompli before the final hearing. The object of interlocutory injunction is to protect the plaintiff against injury by violation of his right for which he could not be adequately compensated in damages recoverable in action. Then paragraph 31, grant of an interim relief is in regard to nature and extent thereof depends upon the facts and circumstances of the each case, as no straitjacket formula can be laid upon. Paragraph 29 is also relied upon. In a case like this, when the applicant approaches the court complaining against statutory authority alleging arbitrariness, bias or favoritism, the court, being custodian of law, must examine the averments made in the application for application to form a tentative opinion as to whether there is any substance in those allegations. Such course is required to be adopted while deciding the application for interim relief. So this judgment, my learned friend has shown, perhaps to negate the order of the Honorable Single Judge dated 23rd March 2021. That order is in my favor, saying that since my right has already been accrued, Your Lordship has got this order 23rd March. Yes. It says that, however, since the petitioner has been selected as the H1 bidder, his interest is also required to be protected. That is what the single bench says. As because field verification has not been completed up till date, now it has been submitted on behalf of IOCL that despite the writ petitioner being selected, selection cannot be said to be set aside or abandoned until and unless it is shown to the satisfaction of this court that in the area there cannot be two distributors. This is a finding and observation of the Honorable Single Judge. He is saying that this finding cannot be taken into consideration because this is an interim finding and rather only a tentative finding which does not have any binding effect. This judgment is on the principles of interim order. The court in this case was considering a prayer for interim order in an interim application writ petition. This order has not been passed by the court while considering an application for interim relief or while considering a prayer for interim relief made by me. Can 4, Can 3 was filed by them by Bimola Gas Service, because there was an order of status which we obtained earlier. Division bench says that you will not do anything without the leave of the court. That is the division bench by which the matter was remanded back, saying that since the matter is sub judice, the status quo as on that date will remain. And if any party wants to do anything, suppose if Bimola Gas Service wants to carry on with the business after distributorship being restored, he will do it with the leave of the court. So for modification of that order, division bench order, this Can application was filed by Bimola Gas Service. And this observation was made, this finding of the Honorable Single Judge was made in that application while disposing of that application. This observation is not made while considering an interim prayer or an interim relief made by me. Because the writ petition is of 2018, the order is of 2021. It cannot be that after 3 years of the filing of the writ petition, the writ court will consider prayer for interim relief. It is after the completion of affidavits. So this judgment that what are the considerations to be made while granting an interim relief, whether the finding of the interim relief are tentative or not, to protect the subject matter of the writ petition, that perhaps this judgment is not applicable because the stage was completely different. And Your Lordship has made this observation finding while considering their application for modification of the order. So this judgment is not applicable in my case. And kindly see, from this order, no appeal has been preferred. If they say that the finding has gone against them, if they were aggrieved by this order, then they should have preferred appeal.
And this order and the last part records further field verification is to be completed within 30 days. It is expected that on flimsy grounds in the name of field verification, the selection of the petitioner will not be cancelled. If such cancellation is required to be made, it has to be made only after taking leave of the court. If you kindly see these last two paragraphs of this order is very important, Your Lordship. Kindly have a look at this order. It's a bit marked. Your Lordship has the copy. My right as a H1 bidder has been crystallized. The Honorable Single Judge has appreciated the fact that my right has crystallized. I have an accrued right. My right should be protected. And this finding was made. Last two paragraphs of internal page 2 and the next two paragraphs of page 3. Yes. Yes, Your Lordship. The next judgment is 2009-5 SCC 694. So this is also on the ground that interim orders, paragraph 21 and 22, that Bimola Gas Service has relied upon. And you see paragraph 21 and 22. A precedent is a judicial decision containing principle which forms an authoritative element termed as ratio decidente. An interim order which does not finally and conclusively decide an issue cannot be a precedent. Any reasons assigned in support of such non-final interim order containing prima facie findings are only tentative. Any interim direction issued on the basis of such prima facie findings are temporary arrangements to preserve the status quo till the matter is finally decided, to ensure that the matter does not become either infructuous or a fait accompli. The observation, this is paragraph 21 and 22. The observation directions of Kapila Hengorani and such, being interim direction based on tentative reason restricted to the peculiar facts of the case involving an extraordinary situation of the human rights violation resulting in the starvation deals. Then, Your Lordship, the interim directions were so clearly in exercise of extraordinary power under Article 142. It is not possible to reach such tentative reasons as final conclusions as contended by the respondent. If therefore the observations are taken to be final decision, it may lead to every disadvantaged group of every citizen or every unemployed person facing extreme hardship, approaching this court or high court alleging human rights violation and seeking mandamus requiring the state. Lordship, this is again on the principles of interim direction. Whether the interim order is binding or not, whether the finding is it says that the finding as but is tentative and it cannot be considered as a ratio decidenda. It is not a final observation. So it is not binding. This is again to negate that order. But this order has not been passed while considering an interim application. The court was not considering interim relief.
Yes.
While seeking modification, the court has passed this order. Observation from this order, no appeal has been preferred. Your Lordship knows that the principles of res judicata, since they have not preferred any appeal, there is a finding. The principles of res judicata, Your Lordship knows that principle applies in similar stages of the same proceeding. At subsequent stages of the same proceeding, even res judicata applies.
if there is a finding of fact made by the single judge while at a particular stage of the proceeding with regard to the finding of fact, and that finding has, if that goes against by a particular party, that particular party does not prefer an appeal, then it acts as a res judicata. I will like to rely upon the latest Supreme Court judgment of I will mention that in my notes. You don't find that judgment in the brief. Roshi, the next judgment is AIR 1963. Now, this I have relied upon. This serial number 16, the judgment in serial number 16, 2007, volume 6, SCC 120. So this is on the point that what is a material fact and what is not. Because I have made an argument that in the writ petition filed by Bimola Gas Service, the restoration of the distributorship was made on 5th of October 2018. That is 5 months after I have been declared as the successful bidder. Now, since Bimola Gas Service is operating in that area, both Bimola Gas Service and IOCL was aware of this fact. They chose not to disclose this fact before the honorable single judge. Because if this fact would have been disclosed, since his restoration of distributorship would have directly impacted my legal right, a person's legal right who has already been appointed as who has already been declared as a successful bidder, and the learned single judge would have at least given a direction to either to the petitioner on the IOCL that you give them notice and add them as a party, because I want to hear them, because without their rights being adjudicated, this petition cannot be taken to a logical conclusion. So this is a material fact which according to me has been suppressed. Both IOCL and Bimola Gas Service, in spite of knowing my legal right which has been accrued, has chose to suppress that fact and has obtained the order behind the back of a party who is a necessary party to the proceeding. Without their presence, the writ petition of Bimola Gas Service could not have been logically decided, logically taken to its conclusion. This is a material fact which I say that since the order was obtained behind my back, affecting my rights, because by that time I was already declared as a successful tenderer, successful bidder. So this order of Bimola Gas Service is a product of fraud, because any order obtained by suppressing material facts amounts to a fraud, and fraud vitiates every solemn act. So to negate that argument, I believe this judgment has been cited, and my learned friend has relied upon paragraph 12 of this judgment. Kindly come to paragraph 12. It is a trite law that so as to enable the court to refuse to exercise its discretionary jurisdiction, suppression must be a material fact. What would be a material facts? Suppression thereof would disentitle the appellant to obtain a discretionary relief would depend upon the facts and circumstances of this case. Your Lordship will kindly pause here for a moment and kindly underline this sentence. A material fact is something the suppression of which would disentitle the appellant to obtain a discretionary relief. So today, if your Lordship, this fact would have been brought to the knowledge of the Honorable Single Judge that look here, even though you are considering the prayer for restoration of the distributorship, but in the meantime, 5 months before, somebody else has already been appointed. So under those facts and circumstances, will you simply restore the distributorship, or you will hear out the party who has already been appointed in your place? Because the advertisement says against cancellation. I will show the advertisement. It says that tender floated against cancellation. So if I have already replaced his position against cancellation, was it not the duty of the petitioner on the IOCL being bona fide litigants, if they were bona fide litigants, to bring this fact before the Honorable Single Judge? If this fact would have been brought, then the Honorable Single Judge would have heard us. The result could have been different, because my right has already accrued in the meantime. So if any fact,
Yes.
this fact could have disentitled the appellant to get the order of restoration as well. Could have. I don't know what would have been the fate, but this fact, if disclosed, could have disentitled Bimala Gas Service to obtain the order of restoration. So that is a material fact. If that fact is suppressed, material fact would mean material for the purpose of determination of the lease. The logical corollary whereof would be that whether the same was material for grant or denial of the relief. So my coming into the picture was very much material for the court to decide whether the court will grant the relief of restoration to Bimala Gas Service or not. So if that fact is suppressed, which will have a bearing on the adjudication process, that becomes a material fact. If the fact suppressed is not material for determination of the lease between the parties, the court may not refuse to exercise his discretionary jurisdiction. It is also tried that a person invoking discretionary jurisdiction of the court cannot be allowed to approach it with a pair of dirty hands. But even if the said dirt is removed and the hands become clean, whether relief would still be denied is the question. So here both Bimala and IOCL has intentionally suppressed the fact that I have already been appointed in his position. I have been already declared as a successful bidder in his position. This suppression of fact is very, very much material. That's why it amounts to fraud. And your Lordship, the last judgment, money এটাই তো last judgment.
Well, this has been repeatedly submitted by Mr. Banerjee that he has not been informed. Because after my submission, he should have amended his submission to the extent that his client has been informed, my lord. No, he has been repeatedly, initially his argument was that he has not
This is the
informed.
practice. When I'm giving reply, he comes and
No, because repeatedly there's a miscommunication or misinformation is being provided.
Let him finish, Mr.
My lord. Because there cannot be a reply of the reply, but he should mend his
You show me one communication that you have.
Okay,
You have informed the petitioner that regarding this pendency or
that is not
information.
I think your junior has not briefed you properly. in that case.
No,
Okay.
I have been. So don't interject.
Next.
Yes. Next is your Lordship 2012, volume 11, SCC, page 1. এগুলো কারা দেখিয়েছে? আমি দেখিয়েছি। 2012, volume 5 টা কে দেখিয়েছে? So this is on the principles of promissory estoppel. This supports my case because this judgment relies upon MP Sugar Mills, your Lordship, of 1917, which I have already cited. Your Lordship will take 182.1 and 182.7. It starts with 182, your Lordship, page 105 of the judgment. So please বসেন না? আপনি বসেন নি? আপনি যে
2012, that is 20th item. Or
Yes, 1 second, Your Lordship. No, yes, yes.
20th item.
Yes, serial number 20.
Mannat Ispat.
Monet Ishpat, yes.
Monet Ispat.
Page 105, Your Lord.
Yes.
Starts from paragraph 182.
Promissory estoppel.
Yes, in my view, the following principles must guide a court where an issue of applicability of promissory estoppel arises. Where one party has by words or conduct made to the other a clear and unequivocal promise, which is intended to create legal relations or affect a legal relationship to arise in future, knowing or intending that it would be acted upon by the other party to whom the promise is made, and is in fact so acted upon by the other party, the promise would be binding on the party making it, and he would not be entitled to go back upon it if it would be inequitable to allow him to do so, having regard to the dealings which have taken place between the parties, and this would be so irrespective of whether there is any pre-existing relationship between the parties or not. So here, Your Lordship, kindly see words or conduct. Here, what are the words and conduct? 31st May 2019. Word says you have been declared as the H1 bidder. Conduct says, pursuant to that, I have given the money which I was required to do. I have altered my position in the form of arranging the land, arranging the godown. Thereafter, field verification has been made. They have found everything in order. That's why they have said the LOI should be issued on 31st May 2018. Thereafter, nothing was done. In the meantime, since we were not, in the meantime, the restoration of Bimala, the earlier player, got restored. So they kept silent about this. They did not do anything. They did not give the tender. Even though my valid right has accrued. So this is a promise in the sense that by conduct, subsequent conduct of the parties after the tender was floated, it amounts to a promise. And I have altered my position on the basis of that. Now you cannot be allowed to go back on your own promise when I've acted on the basis of that. This is the promissory estoppel. 182.2, the doctrine of promissory estoppel may be applied against the government where the interest of justice, morality, and common fairness dictates such a course. The doctrine is applicable against the state even if it is government, public, or sovereign capacity when it is necessary to prevent fraud or manifest injustice. However, the government or even a private party under a doctrine of promissory estoppel cannot be asked to do an act prohibited in law. This is not an act prohibited in law. So there is no legal embargo. The nature and function of the government which the government discharges is not very relevant. The government is subject to the rule of promissory estoppel, and if the essential ingredients of the doctrine are satisfied, the government can be compelled to carry on the promise made by it. The court can force by issuance of writ of mandamus. And Your Lordship, the last line of paragraph 182.1 is important. Kindly see the last line. Having so regard to the dealings which have taken place between the parties, this would be irrespective of whether there is any pre-existing relationship with the parties or not. So even if today there are no pre-existing relationship, it means that we don't have a contractual relationship. There is no privity of contract between me and the IUCL. That really does not matter. If by act it amounts to a promise and I've acted on the basis of the promise, I've altered my position, then the government can be bound, can be mandated to act upon such promise. Then 182.3, the doctrine of promissory estoppel is not limited in its application only to defense, but it can also furnish a cause of action. So this gives me a cause of action to demand a writ of mandamus against them. In other words, doctrine of promissory estoppel can be itself be the basis of an action. For invocation of doctrine of promissory estoppel, it is necessary for the promisee to show that by acting on promise made by the other party altered his position. The alteration of the position by the promisee is sine qua non for the applicability of the doctrine. However, it is not necessary for him to prove any damage, detriment, or prejudice because of alteration of promise. I don't have to show that what damages I have suffered. In no case the doctrine of promissory estoppel can be placed into aid to compel the government or public authority to carry out the representation of promise which is contrary to law, which was outside the authority. It is necessary for invocation of doctrine of promissory estoppel that it is clear, sound, and positive foundation is laid in the petition
Bald assertion, averments, or without any supporting materials are not sufficient. The doctrine of promissory estoppel cannot be invoked into abstract. When it is sought to be invoked, the court must consider all aspects, including the results sought to be achieved and the public good at large. The fundamental principle of equity must forever be present in the mind of the court. Absence of it must not hold the government or public authorities promise, assurance, or representation. This supports my case because I have also relied upon the principles of promissory estoppel of AI 1979, which has been relied upon this case. The same principles have been followed. AI 1979, Supreme Court 6-1, MP Sugar. Now, Lordship remembers that I am not repeating, that I have cited to those judgments that if any action is challenged in a proceeding, which has the impact, if it is either way adjudicated, either in affirmative or in negative, which will have an impact in the rights of a third party outsider who has not been made a party. But that adjudication will affect the rights of a third party outsider. So any order passed in that proceeding without making the third party outsider as a party litigant in the writ petition or in a proceeding, that order is bad in law because of non-gender of necessary party. In my case, I was declared as the H1 bidder. IOCL and Bimala Gas Service knew. In spite of that, they obtained this order without making me a party, thereby affecting my rights. So that order is otherwise bad. And I have also relied upon the judgment that any order passed behind my back, I can choose to ignore. It is not binding. I have a separate legal right which I can proceed. Lordship, this judgment which has been cited are all on the principles of recruitment process and organization guided by certain rules, which is not applicable in a case of tender. So this judgment precedent set cannot be considered as a ratio decedent or a binding precedent with regard to facts and circumstances of my case because it's completely different. On that proposition, I will like to rely upon two judgments. That when a judgment becomes a binding precedent. হ্যাঁ তোমরা দেখিয়ে দেবো দেখা যাচ্ছে এটা কপি দাও এখান থেকে বের করো দিচ্ছি কপি দিস ইজ AI 2004 Supreme Court 4778 ও এই সেলাই করাটা পুরো কপিটা আমার ব্রিফ থেকে বের করো দাও এই আরেকটা পরেরটা বের করো বসে দেখো Now she will see paragraph 9.
But you are now placing new judgments.
This is only on the point since they have cited so many judgments. This is on the principle of law. I believe that there will be no quarrel on this. That when a judgment becomes a binding precedent, when a court should follow a particular judgment for delivering his judgment. So see paragraph 9. Court should not place reliance on decision without discussing as to how the factual situation fits in which the fact situation of the decision on which reliance is placed. Observations of the court are neither to be read as Euclid's theorems nor as provisions of statute and that too taken out of their consent. These observations must be read in the context in which they appear to have been stated. Judgments of court are not to be considered statutes. To interpret words, phrases, and provisions of statute, it may become necessary for judges to embark into lengthy discussion. But the discussion is meant to explain and not to define. Judges interpret statutes; they do not interpret judgments. They interpret words of statutes. Their words are not to be interpreted as statutes. Then your worship, the matter cannot be, of course, be settled merely by treating ipsima vortis of willis as they were on act of parliament. This is not to detract the great weight given to the language. Then your lordship will see the first page, the head note. Under the head note, your lordship, the paragraph 9.
Circumstantial flexibility, one additional or different facts may make a world of difference between the conclusion in two cases. Disposal of cases by blindly placing reliance on a decision is not proper.
So you added as a party in the appellate stage.
Sorry, Your Lordship.
You added as a party in the appellate stage.
Added as a?
In the appellate stage, you added as a party in the Bimola Gas Center. In this case.
No.
Not in this case, that Bimola Gas Center case.
No. I was not a party before the appeal court as well. In the Supreme Court, I was not added as a party. In the Supreme Court, when I got to know that there is an SLP pending, I went and tried to intervene. The court did not allow my intervention or did not give me any precedence in the matter. Court said that matter is remanded by issues kept open. I will show that order. It is part of my affidavit, supplementary affidavit, page 72. I will just, it's a one-page order. Your Lordship need not travel with the brief, I'm just reading it. Your Lordship will see that we have appeared, though we were not added as party. Delay condon, we see no reason to interfere with the judgment and the order passed by the appeal. Consequently, SLP is dismissed. However, question of law is kept open. Our appearance is recorded. Devajyoti Basu, Joyjit Datta, and others. We were never a party. So this judgment is on the point that an additional fact here and there may make a world of difference in the matter. And the judgment is a binding precedent on the facts of a particular case, because precedent of law is set down depending upon the facts of a case. Here the judgment which my learned friend has cited on a recruitment process. Whether right of candidates in a list of empanelment creates any right of appointment in their favor or not. This is factually completely different compared to a tender matter. And the next judgment, Your Lordship, is one more. I will finish. 2006, Volume 1, SCC 368. Lordship, paragraph 9 and 12. The court should not place reliance on decision without discussing as to how the factual situation fits in with the fact situation of a decision on which reliance is placed. Observations of the court are neither to be read as Euclid's theorems nor as provisions of statute. Now, so this is what has been exactly said in 2004 Supreme Court. It has been copied. The same language has been, because it's the judgment of the same judge. So he has used the same language. Paragraph 9 and then 11. Circumstantial flexibility, one additional or different fact may make a world of difference between the conclusion in two cases. Disposal of cases by blindly placing reliance on a decision is not proper. So that it cannot be held as a binding precedent. This is on that principle. And if fact situations is completely different, cannot be held as a binding precedent.
Okay.
Under these facts and circumstances, the Lordship will kindly allow the prayers prayed for in the writ petition. Lordship, I prayed for leave that we will also file a written notes.
You have also already filed it.
Yes, Your Lordship, but this, at that point of time, Your Lordship, when we prepared the written notes, these arguments which have been made, even though not specifically spelled out in the pleadings, but these arguments were made. So additionally, Your Lordship, I would like to file an additional written notes, relying upon this judgment which I have also placed.
Sorry, you can use it. Within 2 weeks. Private S1. You have also used the affidavit, written notes. along with compilation of judgment. Let me find it out. Written notes of argument on behalf of the petitioner.
My lord, the judgment, my lord, you have seen, my lord, that is filed by the private respondent number 5. The compilation of judgment, my lord.
Okay,
My lord, the petitioner is referring the judgment from our notes of argument and compilation, my lord.
Okay. Added respondents.
Yes, my lord, added respondent.
5, 6, and 7.
5, 6, and 7, Bimala Gas Service.
Grateful, Your Lordship, for a patient here. Your Lordship will grant us 10 days time to file the additional return.
2 weeks.
2 weeks. Grateful. Excellent.
Argument on behalf of the parties concluded. Written notes of submission on behalf of the respondent number 1 and 2 taken on record. Petitioner had leave to file written notes of argument within 2 weeks.
Written notes. তুমি তো দাও না।
Let the matter appear in the list under the heading to be mentioned.
My lord, may I get the written notes of argument submitted by the petitioner, my lord?
We will, if Your Lordship directs that, we will exchange the written notes.
Yes, my lord.
Your Lordship will kindly give that liberty in the order.
Okay. On 8th of April.
Well, in that case, my lord, may I take it back and file it since my lord is giving time?
Yes, my lord, in my case also, my lord, we wish to file the additional
My
written notes of
understanding has
argument,
already
my lord.
filed.
My lord, your lordship kindly consider, my lord, in
কি বললাম? না ওটা কাটবো। হ্যাঁ। না parties are at leave. Parties are at leave to use written notes of argument within 2 weeks. 2 weeks after exchange the same between them.
Yes, sir.
Let the matter appear list on 8th of April.
8th. My lord, only a small clarification, since it has fallen from my lord that he has been added as a party in the appeal. Now, my lord, it was part of my submission that, my lord, during this pendency of distribution, we filed the affidavit in opposition against their application for addition of party. That application, my lord, that opposition, we have annexed one letter by, which is, my lord, a letter by Indian Oil addressed to the advocate general of the petitioner, my lord. 17th January, where he was informed about the pendency of the appeal. Perhaps that is, my lord, has noted somewhere by my
yes.
lord. They were informed about the pendency of the appeal. They have chosen not to join the proceeding because this was 17th January, and my lord, the appeal was disposed of in March.
So this letter I am not aware of. I have to take
I
instructions.
made submissions.
He made submission on the
This letter.
That's why I am asking.
So this letter I am not aware of.
Mr. Banerjee is not in the appeal or not.
My lord, is still he saying that he was
not added as a party.
That is why I intervened at that stage.
Your Lordship, the only fact is that the single bench order of Bimala is of 5th October 2018. This letter is of January 2019.
After
Your Lordship, this I have not. এটা কবে ফাইল করেছে?
ফাইল হই তোমার ওই এডিশন অফ পার্টির এগেইনস্টে আছে।
So this I will take is I will delete in the written notes. I will deal it with the written notes. এটা দিয়েছো আমাদের কপি দিয়েছো?
আমার তো সেকেন্ড টাইম দিয়েছি। ওকে তো আবার কপি দিলাম।
আর তুমি বলোনি এটা আমাকে এটা বলছে।
Yes. Next.
Grateful.
Here. Huh?
Your Lordship, we are for the petitioners.
Statement.
We are filing for that affidavit in opposition and reporting the from affidavit. Why not affidavits we have prepared well?
We filed our reply already. We filed our affidavit
Who is for the petitioner?
We are for the petitioners, Your Lordship.
You are for the petitioner.
Yes, Your Lordship.
And you are appearing for the state
State.
respondent. Have you used the affidavit?
Today I am filing, madam.
You are today filing.
Your Lordship, this is our affidavit in reply to their affidavit in opposition, sir. Your Lordship, we've already served to them. Your Lordship, one is an affidavit in reply to their opposition and one is a reply to their report filed by them.
Report in the form of affidavit, one is affidavit in opposition. Okay.
Our reply to both of them.
Both of them. Very good. Yes, what is the matter about?
Your Lordship, this is a writ petition pertaining to resumption. Your Lordship, may I take you to through the facts of the case? Your Lordship, we are being led by I'm being led by my senior who's not being able to present over here, Your Lordship, but I'll start with the facts.
I would hear out whether you are ready today.
Yes, Your Lordship, I'm ready with the facts and I have some few judgments also, Your Lordship.
Very good. Proceed.
Your Lordship, by an indenture dated 29 November 1980, my father, Mr. Nani Gopal Bhattacharya, entered into a lease deed with the governor of West Bengal. And this is a lease deed dated 29th November 1980. And this is pertaining to a plot of land in Sector 3, Salt Lake City. Your Lordship, by a notice dated 27 September 1991, the respondent number 2 had issued a notice to my father. This was 1991, Your Lordship, asking my father as to when will you resume the construction, because there was no construction work done on the said plot of land. By a letter dated 23rd December 1991, my father replied to the said notice of respondent number 2, stating because of the various financial constraints and his reasons for his inability to have any construction work done on the plot of land given to him and construction of the dwelling house. Subsequent to my replies, Your Lordship, the respondents wrote back to me asking me to submit the plan, the construction plan and the layout of the building and various other documents for sanctioning. So subsequent to that notice issued by the respondents to me, Your Lordship, which was 21st March 1992, respondent number 4 inquiring about the said. Your Lordship, may I take you through the annexures as well? Your Lordship, the first notice issued to me is P2 at page number 25. This is our reply, Your Lordship. This is my reply to the notice issued to me by the respondent number 2. Here I have written given my reasons to respondent number 2 as to why I'm unable to start any construction for the dwelling house. This is page number 25, P2, Your Lordship.
Where is the notice?
That is P1. Notice me, I will share it. Not understand. Your Lordship, the 27th September 1991.
25th the notice. 3 page 20.
No, that is the second notice. The first notice is 1991. Your Lordship, that is not annexed, but I have annexed I have replied to the notice issued to me in 1991, which is 23rd December 1991, which is at page number 25, Your Lordship.
Yes, got it. Next.
The next letter by the respondents to me was on 21st, which is the next page, page number 26, dated 21st March 1992, Your Lordship. Here, I am directed to refer to your letter dated 23rd December 1991 on the subject noted above and to request you to let this department know your specific plans and programs for raising a dwelling house on your aforesaid leasehold plot. However, if you require extension of time, you may apply to government for the same, specifically mentioning the time you will require for the proposed construction. Your Lordship, subsequent to this letter, if Your Lordship turns to P4, which is at page number 27, I have submitted such documents to respondent number 3. At page number 27, Your Lordship, this is in the receipt of the documents submitted by me to the Assistant Engineer Vidhan Nagar Notified Area Authority. This is dated 28 September 1992, Your Lordship. Now, here onwards, Your Lordship, I'd like to place. I had submitted my documents, Your Lordship. Now, as per I record, after this, Your Lordship, after I had submitted my documents for sanctioning, Your Lordship, what transpired was my brother passed away in the year 1993, which is, Your Lordship, at page number 28 is the 93, Your Lordship. At page number 28, P5 is the death certificate of my brother. 1993, he expired, Your Lordship, my brother.
What is the name of your father? Nani Gopal?
Nani Gopal Bhattacharya, Your Lordship.
Nani Gopal?
Yes, Your Lordship, my father. Now,
no, your father expired on.
Yes, Your Lordship, my father expired.
94.
My father expired on 94, Your Lordship. My brother expired in 93.
Yes.
My father, a year later, passed away.
Yes, proceed. What
Yes, Your Lordship, thereafter, my father had left behind a will dated 1993. Will dated 2nd September 1993. This is at page number 30, Your Lordship. This is the last will and testament of my father. And my father passed away 11 September 1994, as Your Lordship, I have pointed out, Your Lordship. Subsequent to my father passing away, Your Lordship, we file a PLA number 309 of 1996. Yes, PLA for grant of probate. In the said last will and testament of my father, I have been named as the sole executor.
Okay.
The writ petitioner herein was named as the sole executor, Your Lordship.
What is the writ petition?
Your Lordship, we haven't annexed the writ petition. Writ petition, Your Lordship, or the PLA, Your Lordship.
Page.
Your Lordship is asking for the probate application?
Yes.
Is it probate application? We've annexed the order to the PLA that we filed, Your Lordship, which is at page number 32.
Very well.
A decree was granted in our favor in the said PLA, Your Lordship.
Yes.
It became a contested matter, and then it was renumbered as testamentary suit number 6 of 2007. Now, Your Lordship, the said plot of land was also part of the affidavit of assets in this in the said PLA, Your Lordship. So, Your Lordship, this PLA, this matter was going on, was pending adjudication when, through my advocates, by a letter dated 7th March 2008 at page number 37.
Yes.
I informed the respondent authorities of what is happening as far as this matter is concerned pertaining to the property. Your Lordship, I'll take you through this letter issued by my advocates through me, issued by me through my advocates, which is dated 7th March 2008. At page number 37, Your Lordship. Here, Your Lordship, I have apprised the respondents as to what has happened. I have pointed out to them that my father has passed away. This is a letter dated 2008, Your Lordship. The said Nani Gopal Bhattacharya died on 11th day of September 1994, leaving his last will and testament dated 2nd September 1993, appointing his son Devabrata Bhattacharya, the writ petitioner herein, alias Manas Bhattacharya, as the sole executor of the last will and testament. The said deceased died without constructing any building on the said plot of land during his lifetime, and by the said will, he gave, devised, and bequeathed the said plot of land at Salt.
Last part, one paragraph of page 38.
Yes, Your Lordship. Kindly note that as soon as the said probate will be obtained by our client from the Honorable High Court at Calcutta, our client will take immediate steps for construction of the building on the said plot of land at Salt Lake City, inherited by him from his father Nani Gopal Bhattacharya, the lessee in respect of the said plot of land under Government of West Bengal. As soon as the probate will be obtained, we on behalf of our client inform you immediately. We on behalf of our client inform you immediately, and we shall advise our client to start construction on the building on the said plot of land. Please, therefore, stay your hands for the time being until our client obtains the probate of the last will and testament of Nani Gopal Bhattacharya from the High Court of Calcutta. Your Lordship, I did not receive any reply or acknowledgement for this particular letter. They did not acknowledge as to they have received the said letter or not.
Yes.
But I have informed them, I have put them on notice, Your Lordship. Thereafter, after I receive, a decree was granted in my favor, Your Lordship, which is dated, just a minute, Your Lordship. That is 2019. Your Lordship, in the year 2017, by letter dated 9 January, Your Lordship, I am at page number 39. If Your Lordship comes to page number 39, Your Lordship sees, I have through my advocates issued a notice to the respondents. Your Lordship, I come across in the year 2017 that a board has been affixed on the said plot of land. Addressing this notice that has been affixed on the said plot of land, I address a notice to the respondents, because back in 2008, I had already brought it to the notice that the said Nani Gopal Bhattacharya had already deceased. And what has been happening? Your Lordship, if Your Lordship comes to page number 40, I would like to just point out certain paragraphs over here, Lordship. Upon the death of Nani Gopal Bhattacharya, our client, being his son and sole executor, applied for grant of probate of his deceased father's will dated 2nd November 1993. For grant of probate of his deceased before the Honorable High Court, and the same was registered as PLA. The aforesaid plot of land has been mentioned in the affidavit of assets of Nani Gopal Bhattacharya filed before the Honorable High Court at Calcutta. Copies of the application for grant of probate and affidavit of assets are enclosed for your reference. The said probate application was subsequently numbered and as testamentary suit number 6. Your Lordship, the next paragraph. Since the matter is sub judice, our client is unable to take any steps for development and or construction on the said plot of land, and the same is still lying vacant as it is. We, on behalf of our client, had informed the aforesaid fact to you or at your Sheikh Bhavan, Salt Lake City, by your earlier letter reference number AKG 2000, dated March 4th, 2008. A copy of the said letter is enclosed for your reference. Our client is surprised to notice that recently a signboard has been affixed on our client's said plot of land by EEDMS division of your department, informing the general public that this is a government land. So, Your Lordship, they proceed to They proceed to put up a notice at the said plot of land without informing as to any due process. Your Lordship, thereafter, after there was a decree granted in my favor on 12th June 2019, which is at page number 32.
Yes.
12th June 2019 decree. And then we got a probate. Your Lordship, this is page number 32. If Your Lordship comes to page number 32, this is a order.
Where is the letter dated 27th of October 2005?
27th October.
Where is the notice?
Your Lordship, I'll come to that, sir. Your Lordship, that is annexed to my supplementary affidavit. Your Lordship, I as a writ petitioner, Your Lordship, I had no knowledge of this letter that they allege that they have issued upon me, 2005, the letter dated. I'll come to that, Your Lordship. After the decree was granted in my favor, Your Lordship, I go to the department for mutation of the said plot of land. It is then that I come to know, after I applied for mutation, I paid a sum of 10,000. And each challan in that favor, and each challan indicating the deposit of 10,000 rupees by the petitioner for the purpose of mutation for the to his own name, Your Lordship. I had Thereafter, Your Lordship, I had written a letter. Now, after I write this letter to the respondents, they respond to me and they say that this is the first time they informed to me that this plot of land has already been resumed. Resumption has the government has already taken, the state government has already resumed this plot of land, Your Lordship. If Your Lordship comes to now my supplementary affidavit, Your Lordship.
Yes.
Is Your Lordship looking at my supplementary affidavit? Your Lordship, if here at second page, third paragraph, Your Lordship. The petitioner never received such notice from the. I beg your pardon, Your Lordship. I'll start from second paragraph. The above writ petition has been filed inter alia challenging the alleged resumption of land of the petitioner by the respondent authorities on 21st September 2020, when the petitioner applied for mutation of his name in the record of the respondent number 5. The petitioner was served with a copy of a letter dated 23rd November 2020. In which the respondent number 5 alleged that the property has already been resumed by the government of West Bengal on 27th October 2005, Your Lordship. Kindly take note. And the possession has already been taken by the respondent number 1 on 28th June 2017. The petitioner never received such notice from the respondent authorities, and as such, by a letter dated 31st December 2020, requested the respondent number 5 to supply copies of the purported notices of resumption of the petitioner's land. Subsequently, with a letter dated 13 January 2021, the respondent number 5 for the first time supplied copies of the two purported notices dated 27th October 2005 and 19 June 2017, Your Lordship. The said letter of 2005, the purported notice issued upon me is at page number 4, Your Lordship.
Yes.
Your Lordship, as I earlier stated, Your Lordship, my father had already deceased. This letter was served on my father, who had already died in the year 1994. They say that they issued this notice. I have no knowledge of this notice, Your Lordship. When I issued them a notice in 2008, informing them as to what has happened, that my father has died, that there is a probate petition, there's a testamentary suit ongoing, they do not reply to me, Your Lordship. Thereafter, I further informed them. Even then also, they do not reply to me or send anything. They do not inform me, Your Lordship. It is only after I get a grant of probate and I proceed to get the land mutated in my name, which is when I come to know of these two letters, Your Lordship. The point that I'm trying to agitate over here, Your Lordship, is that this is an order, they passed an order against a deceased person, Your Lordship, which is a nullity.
He was alive then.
Your Lordship, they never addressed me. They've never taken me on record.
No, you are not the party there. Noni Gopal was the party. They served upon Noni Gopal or not.
Who had already died.
Here.
Beg your pardon, Your Lordship?
Noni Gopal was alive there when the notice was served.
No, Your Lordship. Nani Gopal Bhattacharya had died in 1994, Your Lordship. This notice was served allegedly served on Nani Gopal Bhattacharya in 2005, Your Lordship. 10 years.
94.
Yes, Your Lordship. My father died in 1994.
Okay.
The probate petition was of 2006, later 2007 PLA testamentary suit.
Very well. So what is your grounds? Huh?
Your Lordship. Your Lordship, my ground are that first of all, this resumption is bad. They had never brought me on record. They had never recorded that my father had died. And they had never, and this letter also that they alleged to have served upon me, dated 2005, was never served upon me, Your Lordship. They do not reply to my notices that I had issued upon them through my advocates. They had sent no acknowledgement or reply to the same. They had purposely feigned ignorance to the said to the fact that my father had died. And I had sought extension, Your Lordship, which they had initially granted to me. I'm referring to my father when he was alive, when he sought for extension. if your lordship allows us to come back, your lordship, we'll rely on such, there are certain judgments also that we would like to rely upon. If your lordship just grants us another 10 minutes, either tomorrow or whenever.
Reply.
Beg your pardon, your lordship?
In the reply, you can set out the judgments. I have take out the, I understand the facts of the matter. Yes, what is your submission?
Kindly see, my lord, page. My lord,
you have the scope on reply, okay? You have the scope on reply to apprise this court.
Yes, your lordship. Thank you. Much
Yes.
obliged.
kindly see, my lord,
Affidavit in opposition.
P1, my lord. P1, the annexure. They have annexed the lease
Page.
Page, my lord, 17 starts from page 17, my lord, and relevant portion is page 19.
Yes.
But there is a clause in
Is the lease.
Yes, lease deed, my lord. Can you see 6A, clause 6A? Lord, to construct the building in conformity with such building rules as may be from time to time be framed by the government or other authority prescribed in that behalf, according to plan specification, elevation, design, and section sanctioned by the government or that authority within 3 years from the date of possession of the demised land, or such extended time as may be allowed by the government in writing.
Yes.
Therefore, they have to construct the building within 3 years from the execution of this lease deed plan, which they had not done, my lord. Only on that ground, my lord, this is one of the grounds for my resumption of the, my lord, mutation. They, my lord, kindly come to my opposition, my lord. I have stated some facts which are very much required to, my lord, put on record.
Your opposition or report? Opposition. Very.
Page 2 of my opposition.
Yes.
Paragraph 4, I have, my lord, stated some facts, my lord. Maybe allowed to place those facts, my lord. But plot number AC1, I got it, my lord.
Yes.
Plot number AC1 with an area such and such was leased out to Sri Nonigopal Bhattacharya. That is not the part of the petitioner. By executing a deed of lease on 29th of November 1980. And possession was handed over to the said lessee on 6th of November 1981. White certificate number such and such, dated 6th of November 1981. Thereafter, my lord, show cause notice, white number such and such, dated 12th of September 1991 was issued to Sri Nonigopal Bhattacharya under clause 2(6) of the lease deed for failing to construct the house building on the said plot within 3 years from the date of taking over possession, that is 5th of November 1984, and requested him to explain within 90 days why the aforesaid plot of land will not be resumed by the government, my lord. This is in the 1984, my lord. 91. This notice was issued. The third paragraph, on request by the lessee, the department issued a letter white number such and such date 21st of March 1992 and requested to let this department know specific plans and programs of raising a dwelling house on the aforesaid leasehold plot. But it appears no reply was received. Thereafter, my lord, the further final resolution notice dated by such and such, dated 27th of October 2005, was issued to Sri Nonigopal Bhattacharya, lessee therein, under clause 4 of the aforesaid indenture, to remedy the breach caused by violation of clause 2(6) of the lease deed within 6 months from the date of issue of this notice, and specific information that if he fails, neglects to remedy the breach by getting his building plan sanctioned by the competent authority and by starting the construction of the said plan plot within stipulated period, the aforesaid lease shall stand determined, and government will re-enter into the possession of the said land plot after expiry of the aforesaid 6 months. It was made clear that these notice shall be treated as final, peremptory, and no further notice or reference shall be made for taking necessary action for re-entering into the possession of the said plot land in the event of failure to comply with the direction contained therein, my lord. But this notice was issued in the year 2005.
Whether this notice was served?
Yes, no, that was served.
Where is the service report?
Not annexed that document.
At the time the Nonigopal was expired.
That yes, my lord.
And what about the plan you have received on 28th of September 1992?
But we
Whether
have not
you have
received
any
any
instruction?
plan. That is not our document. Can you see my page? Page 27, my lord.
Yes, you have
This has
said.
been submitted to the Assistant Engineer Bidhannagar Notified Area Authority, not before me, us, my lord. Perhaps they have submitted this application for sanctioning building plan.
I think they have not yet received any sanction building plan.
Okay. So this copy was not placed to you.
No.
Very good. So whether the final resolution notice dated 27th October 2005 was served upon the Noni Gopal or any of the heirs of Noni Gopal?
That is not appearing from any, I have not annexed any documents.
What about the report? This is the only grievance of the petitioners here.
But they have failed to construct within us.
What is the? I understand everything. Whether you have served the notice whether upon the lessee or any of the heirs.
Yes, whether
This
they
is
have
the only
received,
grievance here, nothing more, nothing less. You have initiated a proceeding without serving a notice.
whether
This is the only grievance here.
yes,
Do you have anything to say that yes, we have served or we have affixed? What is the report? Service of notice may be another mode. What you are saying about that?
we have stated in our report also paragraph 4, page 4, paragraph 4.
What you have stated?
For the so-called notice, white number such and such, dated 27th of October 2005, was issued to Sri Noni Gopal Bhattacharya, lessee, under clause 4 of the aforesaid
Report in the form of affidavit.
Yes.
Paragraph?
Page 4, paragraph 4.
Page 4. Statement of facts.
Yes, ma'am. Yes.
What statement? Statement prepared by the department.
Yes. Land manager Vivanna.
Yes. What is the report says?
Paragraph
So-called
4.
notice dated 27 was issued to the Noni Gopal Bhattacharya.
Yeah, what is it?
When he was dead.
That have to take instruction whether
To take proper instruction. How you serve the notice. Whether you have at all served the notice. That is the only question.
Your Lordship, may I point out one more point, Your Lordship?
No.
This is pertaining to the
They
lease.
have not concluded.
Very
They
good.
have not. Let them conclude it.
Another thing is, kindly see next paragraph, page 5 of my report.
Page
5. Page 4, paragraph 5. Next.
Let them finish first. Thereafter, you take note. Report page 5.
Yes. Page 4, paragraph 5.
Page 4, paragraph 5.
What? Yes. On 22nd May 2006, a letter received from Sri Somnath Basu, SI of Police CID West Bengal, against Sri Noni Gopal Malar Bhattacharya instead of Chakraborty. Plot number AC under Rajarat PS case number such and such, such and such.
It is, you're reading it wrong. It's Chakravarti. It's written Chakravarti, not
But that
Bhattacharya.
is mistakenly under Chakraborty. Plot number is the same.
That notice also is all, it says Chakravarti, not Bhattacharya.
From the said letter, it appears as Lessee Noni
The
Gopal.
annexure also
What are you
says,
saying? Paragraph 5.
Yes, my lord.
Read out.
My lord, on 22nd of May 2006, a letter received from Sri Somnath Basu, SI of Police CID West Bengal, against Sri Noni Gopal Chakraborty. My lord, it would be my lord Bhattacharya instead of Chakraborty. It is the mistakenly my lord.
Your Lordship,
Of plot number AC1 under Rajarat PS case number 49 dated 2nd of February 2006 under section 420, 486,
2000?
2000,
26 or 16 or 6?
It will be 2006.
2006. If it is 2006,
2006.
How can a case be registered against a dead person? Criminal case?
and this is not the person also.
Made it transfer.
Wrong person's name
But
is
this
also.
plot has been transferred illegally in favor of some other person. That is on what PS case has been started against my lord Sri Noni Gopal Chakraborty.
This is take your Lordship to the affidavit of observation.
So how you registered a case against a dead person?
Page number
Sir, take my relevant documents is
You
required.
take instruction, proper instruction. Yes, paragraph 6 you read your report.
Yes, sir. Thereafter, the lessee Nonigal Bhatt expired on 94.
Yes, 94 he expired and he started a case 2006. You have admitted that he expired in 94. What about your criminal case? What about your notice? What about the proceeding? Without serving notice, you take proper instruction and come.
Yes.
Let the matter appear in the list next week, Monday, under the same heading. Order the country. Next.
Much obliged, Your Lordship.
Well, I should give reply for Gargi. Gargi is concerned. Gargi Mondol. Gargi.
3 writ petitions have to be taken together.
Yes. There are 3 writ petitions. One has already been concluded. Mr. Surjit Mitra has concluded his submission. So far the reply is concerned. Another 2 writ petitions, I appearing on matter and Mr. Parthasarathi Bhattacharya appearing on matter. So I shall conclude this submission. So
We have concluded
no, I have not given reply. I shall give reply today.
in Gargi's matter. In
Gargi's
Gargi
matter.
matter.
Gargi. তাই তো গার্গিতে অপোজিশন ফাইল করেছে দেখুন অয়েল কোম্পানি, ওটা একটু দেবেন। গার্গির ফাইলটা দিয়েছেন জোসেফকে?
Yes.
My lord, opposition filed by the oil company, you have to kindly take up in Gargi matter that has been affirmed on February 2022, no date has been given.
কিছু তো নেই, শুধু তো অর্ডার গুলো পড়ে আছে, দেখবেন তো।
এই নিচে দেখুন ফাইলটা নিচে।
কিছু নেই এখানে, শুধু অর্ডার শিট পড়ে আছে আর কিছু, শুধু অর্ডার কপি, অর্ডার বই। প্লিডিংস কোথায় গার্গির?
এটা হলো 2124, 8125 কোনটা? অন্তরা থাকতে পারে, হ্যাঁ। দ্যাট অপোজিশন হ্যাজ বিন প্লেসড বাই জাস্টিস মিস্টার মিত্র। ওই যখন সুরজিৎ আর্গুমেন্ট আমাদের এটা থেকে দেখিয়েছিল, হ্যাঁ দেখিয়েছিল, এইটা তোর এই কাগজটা
এখানে আছে না চলে গেছে?
একটা চিঠি দেখিয়েছিল আমার মনে আছে।
হ্যাঁ ঠিক আছে,
হ্যাঁ সেইটার জন্য ফাইলটা হয়তো ওখানে চলে গেছে।
কখন সময় চলে গেল বাড়ি থেকে, চেম্বারে চলে গেল।
একটা টাকা বাদ দিয়ে দেওয়ার কি ছিল, একটা টাকা বাদ দিয়ে দেওয়ার কি আছে বুঝতে পারছি, এই চিন্তা দিকে।
All pleadings has gone with Antar.
কবে থাকবে ফাইলটা চলে গেছে। Any day, your lordship, subject lordship.
All pleadings are kept with Antar.
ঠিক আছে।
Any day, your lordship, kindly keep.
Only order sheets are, all order
Very
sheets.
well, I understand. Anyway, tomorrow, day after tomorrow,
Subject
whatever.
lordship consider.
Okay. Hey, direct them.
Since your lordship expressed your lordship's intention to complete the hearing at least within.
I have no difficulty. Thursday, possibly, my lordship, after service matter, subject to lordship.
The 2 days remaining, by Tuesday.
This Thursday?
This Thursday.
10:30? কি আছে একটা? 10:30.
My lord.
10:30.
I will conclude both the matters. Okay. এই ওইটা নিয়ে আসবে, চেম্বার থেকে নিয়ে চলে আসবে মনে করে, এক্ষুনি গিয়ে বেঁধে রাখো এর সামনে।
Thursday 10:30.
Let the matter appear in the list on Thursday, that is 13th of March 2025 at 10:30.
Okay.
Next.
My lord, 8, my lord, I am for the petitioner, my lord. Actually, my lord, the petitioner has expired, my lord. The legal heirs have been
Okay, I understand.
substituted, my lord. My lord, I need certain instructions from the legal heirs, my lord. The present status, what is happening. So, my lord, I am praying for
Petitioner expired.
petitioner expired, and my lord, the legal heirs have been substituted by your lordship, my lord.
Was it substituted?
Yes, my lord.
Substitution application allowed.
Yes, my lord. Your lordship has allowed, my lord.
So what you want
Substitution.
now?
My lord, only, my lord, I need certain instructions from the legal heirs. The present status, what they are. So, my lord, I'm praying for 2 weeks' time.
Let the matter go out of the list, okay? You can say.
Not go out of the list, my lord. Let it appear, my lord, after 2 weeks, my lord. If it is out of list, my lord, then, my lord, it's very difficult to trace the files.
Let the matter appear in the list on 9th of April under the same heading.
My lord, I'm grateful, my lord.
Next.
Item 10, Lordship, I'm for the petitioner. Interim order has been expired, Your Lordship, on 12th March.
Right.
12th March. No report in the form of affidavit, Lordship. Your Lordship has directed to file the affidavit by the state.
12th of March. Okay. Please take down. No report in the form of affidavit was placed on record by the state respondent. Interim order passed by this court was expired on 12th of March 2025. Considering the situation, in my view, the interim order requires to be extended further. Next, let the interim order passed by this court is further extended till April 30th, 2025, or until further order, whichever is earlier. Let the matter appear in the list on 21st of April under the same heading.
Grateful, Lordship.
Call motion. Next.
My lord, kindly make a short passover, my lord.
Passover now.
My senior is on the way, my lord.
Next.
28, Your Lordship, I am for the petitioner led by Mr. Sagar Bandyopadhyay. Your Lord, may I start?
কেন করেননি কেন? সার্ভারও তো হয়নি। এগুলো কি যে করছে, সার্ভারও করছেন না, সইও করাচ্ছেন না। নিবেন, এটা সার্ভার করেছো? এটা সার্ভার করেছো লাস্ট একটা? সার্ভার নেই তো করা। সই করেননি কেন? সার্ভার করে দিও দুটো আজকে, ঠিক আছে? Mr. Amrudulal Chatterjee was for the state.
Pardon?
Yes. What is
Your
the matter?
Matter is, Your Lordship, one vacancy has been declared. If Your Lordship kindly come to page 25. This is the vacancy notice. and vacancy has been
Affidavit of opposition has been filed.
Yes, my lord.
So why is
Opposition
it appearing under the heading of motion matter?
Your lordship was pleased to direct that matter will appear under
The heading of motion.
motion, your lordship.
So that finally the matter can be
Reply
disposed.
has already been submitted before your lordship on last occasion.
Very well. What is the issue?
Issue is, your lordship, vacancy has been declared.
Yes.
Then petitioner has been submitted his application. There was a condition in the vacancy notice. If your lordship kindly come to page 25. Page 25 of the writ petition, your lordship. This is the vacancy notice. Vacancy has been declared at page 27, serial number 37. That is Mondolpara under Horiharpara GP, Gram Panchayat. In the vacancy notice, there is a condition. The application for dealership must have bank balance at least 5 lakhs as working capital reflected on the application preceding 1 year of the date of application, your lordship.
Yes.
Your lordship, next, if your lordship kindly come page 28. Vacancy has been declared at page 27 on 12th of February 2019. Serial number 37.
Mondolpara.
Mondolpara under Horiharpara GP.
Okay.
12th of February 2019. Thereafter, your lordship, if you kindly come to page 28. This is a fixed. I am led by Mr. Bandyopadhyay.
Yes. Mr. Bandyopadhyay, start.
My junior has shown your lordship the fixed deposit which we are having. Now the license was granted. The challenging grant of license, another candidate, he approached before this honorable court by filing a writ petition. That writ petition was rejected with cost. After that, he made a complaint that I did not maintain rupees 5 lakhs for the last, for the preceding 1 year before the applications. Now a report was called for from the State Bank of India. Now the report says that from the account, the 5 lakhs was withdrawn. That was what the subdivisional controller did. He straightway issued a notice of hearing. First, you will also kindly take page 29A, that is my license.
Yes.
But why this is relevant, kindly keep it in mind that the license was already granted. After the process of the applications, after inquiry, it was granted on 9th of January 2023. You also will get the date at the bottom of that left-hand side bottom. Now this hearing came, next page, page 30, 4th March 2024, nearly after 1 year. Yes. After dismissal of the writ petition of the other applicant, that is Rakesh Singh. Now, for 1 year, the petitioner has run the dealership successfully. That is relevant for the purpose of the provisions of clause 24 of the control order. Now, this is the only hearing notice given. I attended the hearing. I submitted, in course of the hearing, I submitted that particular fixed deposit certificate showing that I had a bank balance, I had a fixed deposit of more than 5 lakhs. Now, kindly take this, the verification after 4 paragraphs. After 4 paragraphs, page 31.
This is the, after the hearing, this is the order of the subdivisional controller. Now
Yes.
kindly take whereas the then SCFS, as you last got it noted after fourth paragraph,
Yes.
paragraph 5. Whereas the then SCFS for the put up an e-file by file number such and such to the higher authorities of the Food and Supply Department through proper channel, recommending termination of the provisional FPS license to the Khurshid Alam Khan and seeking necessary instructions regarding the matters. So, the SCFS forwarded the file saying, proposing that it should be terminated, he should be terminated. Now, they record the personal hearing. They did not record that I had shown them the fixed deposit certificate. Kindly come to next page. They relied on the report of the bank saying that I had withdrawn the 5 lakhs rupees after depositing it. Then, last concluding paragraph, therefore, in view of the above, FPS dealership, Khurshid Alam Khan, for such and such, hereby placed under terminations. I don't know, either it is terminated, it cannot be placed under terminations. It's not like suspension. It's hereby placed under termination, and they say the FPS is hereby tagged with the nearby FPS shop. Now, before proceedings further, I'd say the subdivisional controller committed 3 illegalities. First, before time, there is only provisions under clause 24 of the control order for termination of a dealer. If you
Clause 24.
Clause 24. Page 1.24 of that book.
Yes. Yes.
If a licensee or his or her agent or any other persons acting on his or behalf contravenes any of the provisions of this order or any of the regulations made thereunder or any other condition of his or her license or any discrepancy of stocks or in the OEM devices is detected, the subdivisional control food and supply shall issue a notice. Kindly mark shall issue a notice to the concerned dealer asking for explanation in writing for such contravention and discrepancy, and may also place the dealerships under suspension till the disposal of the proceedings by the subdivisional controller. In case of suspension, the concerned ration card holder shall be tagged temporarily with the neighboring dealer. The licensing authority, after giving the licensee an opportunity of being heard and after recording the decision thereof, may terminate the license or may reduce the volume of the business through reductions of the tax license are imposed according to the gravity of the offence as annexed in Schedule A. In case of imposition of fine, such and such. Clause 24 has 2 relevancy in this present case. One is, kindly see the grounds on which a proceedings can be drawn. Clause 24 refers to a drawing of proceedings. For against a licensee, or his or her agent or any other persons acting on his behalf contravenes any of the provisions of this order. This order means PDS Control Order 2013 or any of the regulations made thereunder. There are certain orders time to time are issued. If the power is given to the concerned food and supply authorities, if that regulations is issued, then if someone contravenes. Now, third one is that any conditions of his or license or any discrepancy of stocks in the OEM devices is detected. So, under these 3 circumstances, a show cause proceedings can be drawn under clause 24. If there is violation of a control order,
yes.
If the violation of any regulations, or violation of conditions of license or any discrepancy of stocks.
Yes.
I was granted on 9th of March 2023 the license. I continued for 1 year as a licensed dealer. But notice of hearing came on 4th of March 2024, the more than 1 year.
Yes. Yes.
So at that time, when this notice of hearing came, I was a full-fledged licensee. So if subdivisional controller was desirous in proceeding against me under clause 24, he should have first issued a show cause notice, formulating a charge. Charge means formulating a specific allegations of violations of the provisions of the control order or the regulations made thereunder or the condition of license. Then only, thereafter he could place me under suspension and then proceed to hear me and pass the termination order. Here, your lordship will not find any show cause notice, making any specific charge against me. The first violation is there is no show cause notice. That is, in deviations with the procedure prescribed under the statute.
Yes.
Second is, at that time when this hearing or proceedings was sought to be initiated, there was no allegation of violation of any provisions of this control order. There's no allegations of violations of any regulations under this control order. There's no allegation of violation of any of the conditions of the license. So these charges were absent. This is the second. Third one is, he proceeded to hear it, but it is apparent from that order that he was predetermined even before proceeding against me, because he already sought for permission from the joint director in May 2023 to terminate. Kindly come back to page 31 and the 5th paragraph. See, he already, before even giving any opportunity of hearing or even before issuing of any show cause notice, he already determined to terminate. The glaring example, of the closed mind and the violation of principle of natural justice. The control order doesn't give any authority upon doesn't vest anything upon the subdivisional controller wherefrom he can seek any instructions or directions from the superior authority. In fact, the superior authority where the file was sent, under this appeal provision, he was the second appellate authority. From the director, he sought instructions. He was the second appellate authority.
Yes.
Now, the petitioner should not have preferred any appeal because the order was without jurisdiction, order was in violation of the principle of natural justice. So he could have directly come before this honorable court. Anyhow, he chose to prefer the first appeal before the district controller. The first appeal is page 33.
Yes.
Whereby he relied on that from the subsequent change in the system, he was required to maintain 50,000. These are the grounds. I am not concerned. My lord, page 34 is the hearing notice and 35. Now the order is page 36. Why I am showing? So these are the incidences. This should have been looked into at the time of inquiry. I submitted the bank details. I claimed that I had the deposit. That was a thing which should have been inquired into. That is why when someone is applies for the dealership, his application is considered now. And physical inquiry is made into the particulars mentioned in the application. But now this endeavor has been taken. But after grant of license, nearly 1.5 years after the grant of license, both by the SCFS and DCFS, and this power, it is not available either even under the vacancy notice. But for the time being, even if I proceed, that I claimed I made a false statement or I gave a false. In fact, there was no false statement. I produced the bank and it was there. I withdrew it. Even if that stage is over. The vacancy notice said that during inquiry, if it is found that this is not maintained, his application is liable to be rejected. Even the vacancy notice doesn't give them power that even after grant of license, it can be looked into and his license may be cancelled. I would have accepted it. Now, I had bona fide because I had a fixed deposit of 6,50,000. I will show from my appeal statement as well as from their affidavit that they did not deny that I had produced this document before the concerned authority during the in course of the hearing. Now, so the DCFS rejected. Then kindly take the relevant page 38. This is my second appeal before the director. In fact, it is that person from whom the instruction was sought for by the SCFS for terminating. And after getting his approval, he terminated. Now again before this authority, I am to file the second appeal. Page 38.
Yes.
Kindly take subparagraph Roman 2. It clearly mentions, my lord, that I had 5 lakhs, more than 5 lakhs in the form of fixed deposit from 12th of September 2017 to 11th of September 2027. My lord, kindly take next page 39. Subparagraph 5 in the aforesaid paragraph, the Vice notice doesn't say the subject matter instructed me to appear before him for personal hearing on 6th of March. Pursuant to such hearing notice, I attended the hearing and produced all relevant documents, including copy of the fixed deposit certificate of rupees 6,50,000. And these facts have not been denied. I will show from the petition also. Now, next page 40. The paragraph Roman 9, I have taken this point that it appears from the order of termination dated issued by such and such issued by such, that he has passed the order as per directions of the second appellate authority. This was also taken as a ground. Now, the grounds of challenge Roman 2, by way of not issuing show cause notice, allowing me to submit my reply denying and disputing the allegations of the show cause notice as per clause 24 of the control order. Well, this is a basic limb of natural justice that if any action is taken which has civil consequence, the actions to be proposed in the show cause notice. Your Lordship has probably gone through many judgments where the action is not proposed. but that action is taken, my lord, it is held to be in violation of the principle of natural justice. But starting from blacklisting, starting from, my lord, termination of the contract. Now here, there was no so-called notice, no action was proposed. My lord, because there are 3-4 options given under clause 24. One can be fined, one can, ration cards can be detached, and the final thing is termination. My lord, if the action was proposed that now you will be fined or you will be terminated or you will be, this number of ration cards will be tagged, I would have given that specific reply, my lord, defending my case. My lord, that so-called notice is action. So there was no action proposed. I rely on, in this aspect, my lord, I have judgment.
Yes.
My lord, then page 41, ground 6. Now the prescription of the vacancy notice suggests 5 lakhs in the bank account for the period from 15th March 2018 to 15th March 2019. But my 6,50,000 was there from 12th of September 2017 to 11th of September 2027. Which is much more than what was, my lord, reasonably required. There is no, my lord, mandate under the regulations, my lord, to that effect. This is in the form. Even the form was, my lord, didn't say specifically. It says that 5 lakhs as on the date. What is the bank balance as on the date of the application? I'll show the application form. It doesn't say that did you maintain this amount for the last 1 year. That was in the vacancy notice, but not in the form. Now the second appellate authority also, just because they have already decided to terminate, because it is this second appellate authority who instructed, who approved that my termination. So he affirmed the order passed by the sub-divisional controller and district controller. Now the fact remains, if the original order goes, if the original action is without jurisdictions, all subsequent actions goes. Clause 20 টা কি বলছে? সব জায়গাতে দেখাচ্ছে ক্লজ দেখাচ্ছে যে ক্লজ 20 করছে 5 লাখের কন্ডিশন Now kindly take page 45. Decisions with reason. Malad, the second appellate authority refers to a GO number 21st of July 2014 that purportedly stipulated that the applicant for dealership must have bank balance of rupees 5 lakh as working capital as reflected on the day of application and 1 year preceding the date of the application. That GO was relied upon. This is a vacancy notice. A vacancy notice is there and there is a prescribed form one has to apply. Now, report of the branch manager says that I had deposited 5 lakhs and had withdrawn on the date of application. Now, next page, Malad, page 46. First paragraph. As per clause 20 of the West Bengal PDS and Maintenance and Control Order 2030, Government in Food and Supply Department is the final authority in case of engagement of APS dealer against the fresh resulted vacancy. Hence, there is nothing wrong in the action of SCFS. I'm pausing here for a moment. My lord, it is the final authority at the time of granting the license. Now, after the license has been granted, rightly or wrongly, then one has to fall back to clause 24 for terminating such dealer. Because the engagement part is over, long over. Yes. Now, kindly take the report. First, you will also kindly see my paragraph. সেটা কোথায় কোন প্যারাগ্রাফে বলেছি দাদা আমাকে আগে মার্ক করা আছে paragraph 11, kindly take my paragraph 11 of the writ petition. Your petitioner states at the time of hearing, your petitioner categorically produced all relevant documents, including the copy of the fixed deposit certificate of rupees 6,50,000 for the period from 12th September 2017 to 11th September 2027, fulfilling the financial eligibility criteria. Your petitioner further stated during course of hearing, no such complaint had been had over. That was the complaint of Rakesh Sheikh, whose writ application was dismissed. Now, next, Marath, after completion of the hearing, your petitioner has been forced to sign some papers initially, although your petitioner refused to sign those papers. However, under pressure of number who were also present during the course of such hearing, your petitioner has been forced to sign those documents as per instruction of the sub-divisional controller. So these are the two allegations I have made. I have made that I have produced the 6,50,000 document before the sub-divisional controller at the time of hearing. And next, certain documents were forcefully signed by me. Now, this has been dealt with in the report filed by them. I'll put this in the opposition. Kindly take paragraph 11 of that opposition. Paragraph 9. At page 10. Yes. That the statements made in paragraph 19 writ petition, several what are matters of record, and those are specifically admitted therein. Rest of the evidence contrary thereto and are denied and disputed by it is specifically mentioned here that was the complaint of Rakesh Sheikh, one applicant of the aforementioned vacancy notification, gravity of the allegation, subject order inquired about the matter, and for authentication of the financial, the bank statement of Khorsad Kalam Khan was sent to branch manager such and such for verification of his genuineness during the period from 5th of March 2018 to 5th of March 2019, whereas 11th March 2019 being the date of application and 11th March 2018 being the 1 year preceding the date of application. According to the verification report, branch manager declared that as on 5th of March 2018, 1 year preceding the date of application, the amount was rupees 581.82, and as on 11th March on the date of application, the amount was rupees 786.32, which was available in the bank account of the. In this juncture, the area inspector was also directed to verify the bank balance with original passbook bearing such and such at the which was produced by the petitioner at the time of processing of the said vacancy by memo number such and such, dated 12th of February 2019. It reflects from the said submitted bank document that as on 11th March, the day of the application, the amount was 5,22,887.32, and 11th March, 1 year preceding, the amount was 528,306.22. Therefore, it is crystal clear that the petitioner had submitted a fabricated bank statement at the time of applications, and also it is also mentioned herein that in reliance of these false and fabricated tempered account statement, in reliance to the account had obtained APS dealership license as such and such in the district municipal in sequence of the. It is pertinent to mention here that in personal hearing, petitioner has admitted his misdeed. Petitioner relied the bank account of John Mohan. Account of John Mohammed Pures QUS Limited in the In the first time in the writ petition, try to make out a separate case. It is specifically mentioned herein that anywhere in the office records, such as his application form C and inquiry report note sheet for recommendation, the only bank account detail found in the office record of the statement is basically denied. Now it is applications in form C submitted. The petition is annexure 2 and marked as annexure A4. Now kindly take A4, my lord, annexure A4, page 27.
Yes.
Now, kindly come to serial number 16. I, amount of money which can be invested in the business of dealership, 5 lakhs. Name of the bank and its branch in which account is maintained, that is SBI. That was the regular savings account is maintained. Credit balance as on the date of applications is 501287. Number of hired person to run, if necessary, 1 person will be hired. Such and such, this was my application. Now, if purported report has been relied on, page 19 is the statement of account which was relied on. Now, kindly take page 21. Have you got page 21? But on 8th March 501287, you will also will find it was the credit balance, rightly or wrongly available. Now he had in his application, kindly come back again. You will also will find this exact amount of 50187. 1287. Kindly come back to page 27. You will also will find this is the amount he put, my lord, in his application.
Yes.
Now, the kindly take clause 20 as well as but
yes.
Now kindly take clause 20. Now engagement dealer, page 1.17. Would you continue? I can continue.
No.
Clause 20 is the provisions for engagement of dealer. Now the applications in form specifically subclause 3. Subject to the date sheet mentioned in subclause 3A, applications for filling up vacancies as notified in clause 2 here and above shall be invited from such and such persons on receipt of the application in form C, along with annexure 1, requisite fees as prescribed, corroborating documents as per checklist within the subdivisional court of prudence shall process the case and get the case inquired into by competent officer or group of officers and send a report in form mail with its comments in form M to the concerned district controller, food and supply, and the said district controller, food and supply shall place the matter before the district fair price shop selection committee and forward their decisions with his comments to the director DDPS, and in turn shall forward the same to the department with his specifications. Whereas in case of tea garden, we are not, my lord. Then after the entire process of children, dealers clause 1 and 2 shall, as far as provided, be completed as per date schedule. Following person shall not be eligible. There is no mention of my lord maintaining 5 lakhs. In any event, my lord, we take it from granted, but that stage is over.
Tomorrow? Yes.
Tomorrow. Maybe at 2 p.m.
No. First, let me see what happened. Okay, yes.
Follow the other. তুই আছিস তাহলে সোনাল সিনার হয়ে টাইম নিচ্ছে কেন আগে
এটা কাকে সাজেস্ট রেখে দিলাম আগের দিন এই স্টেজ থেকেই রাখবেন প্রথমে তো আছে সেটা ফার্স্টটা সব আর কোন ম্যাটার থাকবে আর মোশন ম্যাটার হবে তারপরে যে রান করছে আর কি লিস্টের ওই কথা সব লিস্টে জোড়া
মানে ধরলো
অ্যাসাইনমেন্টের সব শেষ হয়ে গেছে স্পেসিফিক ফিক্স ম্যাটার শেষ হয়ে গেছে ফর অর্ডার ম্যাটার চলে গেছে স্পেসিফিক্যালি অ্যাসাইন ম্যাটার গুলো একটা রয়ে গেছে না টুডি মেনশন ম্যাটার একটা রয়ে গেছে ঠিক তো কালকে তাহলে মোশন ম্যাটার নিয়ে ফার্স্ট হবে মোশন ম্যাটার তারপরে যাবে ঠিক আছে tomorrow I will take up the matter at 10:30.
If I could not, if I cannot reach my
I will take up the motion matter first tomorrow.
So then after that you will see.
No, not after that. This is coming under the motion matter. প্রথমেই চলবেন একটা বড় ম্যাটার
As a lordship, my lord.
Whether it was listed list number 82, today's list, it will take up tomorrow. I will take up motion matters tomorrow first. Okay. All the matter will take, no issue. All day long the motion matter will be gone. First motion matter, if Mr. Agarwal, whether Mr. Bandopadhyay, if not appear, I will take up the after motion matter. Your matter. Okay. If you could not reach, then I will take up your matter after completion of motion matter. Let's see if then tomorrow item number 80, 82. Not more matter, last matter, your matter. I will take up your matter. রাখুন কালকে রাখবেন ওকে